Acá dice que sí, ¿eh? Les agradecemos que vayan tomando asiento. Vamos a cerrar las puertas para comenzar. Hola, hola.
La de la izquierda. Abajo.
Voy a partir entonces.
Perfecto. Sí, la de la izquierda.
Bueno, buenos días a todos. Vamos a comenzar los trabajos del día de hoy, después de una fantástica inauguración de la COP encabezada por el presidente de la República Argentina, don Alberto Fernández, y obviamente con la participación de nuestro secretario ejecutivo adjunto, varios ministros y altas autoridades, los representantes también de la CAF y, por supuesto, los representantes electos del público. Hay que agradecer a la República Argentina por la organización de tan brillante inauguración. Como saben, la primera conferencia de las partes del Acuerdo de Escazú se celebró el año pasado en Santiago y en esa conferencia se determinó organizar una reunión extraordinaria de la conferencia de las partes y la República de Argentina se ofreció a hospedarla. Y ese es el motivo que nos convoca a todos aquí. En la primera conferencia de las partes también procedimos a elegir a la nueva mesa directiva, que está compuesta por el Uruguay como presidencia y 4 vicepresidencias: Antigua y Barbuda, la Argentina, México y Santa Lucía como las 4 vicepresidencias. Según las reglas de procedimiento de la conferencia de las partes, corresponde a la presidencia de la mesa directiva presidir las reuniones de la conferencia de las partes y también informar brevemente de las actividades que se realizan por la mesa y, por supuesto, dar la bienvenida a esta conferencia. En ese sentido, quisiera invitar, en primer lugar, a don Marcelo Causillas, director del área jurídica del Ministerio del Ambiente del Uruguay, en calidad de presidencia de la COP, a que nos dirija las primeras palabras. Adelante, Marcelo.
Muchas gracias a la Secretaría. Gracias, Carlos. Señores miembros de las delegaciones de los Estados parte y de los Estados signatarios, representantes electos por el público, invitados, amigos, amigas, bienvenidos a Buenos Aires, bienvenidos a la República Argentina, bienvenidos a esta segunda reunión de la Conferencia de las Partes del Acuerdo de Escazú. Para mí es un honor, un gusto recibirlos en esta instancia como presidente de la mesa directiva. Después de haber vivido una sesión inaugural memorable en el día de ayer, a la que espero que todos hayan podido asistir, estar presentes junto con el presidente de la Nación Argentina, con muy destacadas autoridades de la región, que nos dejaron mensajes muy claros. Un evento que nos permitió dar la bienvenida a los nuevos países partes del acuerdo, a Belice, a Chile, a Granada, y como dijo la ministra Silva de Brasil, que ayer también nos honró con su presencia, nos brindó esa conexión tan especial que la música y la poesía nos da desde el arte. Hoy en cambio, comenzamos a transitar otra forma de arte. Hoy empezamos a trabajar en lograr un acuerdo, un nuevo consenso entre nuestros países para cumplir el objetivo, la meta principal que presenta el temario de esta reunión, que tiene carácter extraordinario. Ha sido convocada con el objetivo de elegir a los integrantes del Comité de Apoyo a la Aplicación y el Cumplimiento, cuya relevancia creo que todos conocemos. El Comité de Apoyo a la Aplicación y el Cumplimiento es esencial en la estructura del acuerdo para la implementación de los derechos de acceso. Por tanto, otros temas también muy trascendentes que tenemos entre nosotros, que estamos trabajando, que están pendientes de operatividad y resultados, serán objeto de nuestra tercera reunión de la Conferencia de las Partes, de la segunda reunión ordinaria que se celebrará en el año 2024. El interés que despierta el acuerdo ha quedado evidenciado en la cantidad de inscriptos, que supera ampliamente las posibilidades locativas, las de organización, lo mismo que el número de eventos paralelos y actividades asociadas que se proponen en torno a nuestra reunión. Solo para tener una idea más o menos de la dimensión que va tomando nuestro acuerdo y estas reuniones, consideremos que hemos recibido inscripciones de 110 personas de delegaciones de estados parte y de estados signatarios, 70 representantes de organizaciones internacionales, gubernamentales y no gubernamentales, interesados en estar entre nosotros. Más de 30 representantes de la prensa nos van a acompañar desde el día de ayer y a lo largo de nuestras sesiones. Se han recibido casi 500 solicitudes de inscripción de parte del público y se han podido inscribir efectivamente más de 350 personas que integran el público. Lamentablemente, algunas personas no han podido ser personalmente aceptadas para asistir a nuestras reuniones, a nuestras sesiones, a las que pertenecen a la agenda oficial, pero, como comentaba antes, sin duda existe un cúmulo de actividades presenciales y online en torno a la sesión a la que podrán también asistir. Además de la transmisión directa, esta sesión puede ser seguida desde cualquier punto porque estamos transmitiendo online. Es decir, la más amplia participación, las más amplias posibilidades que nos dan las condiciones y los límites, evidentemente, del financiamiento. Ustedes disponen de un temario provisional que, dado el carácter de la reunión, está directamente orientado a la elección de los miembros del Comité de Apoyo a la Aplicación y el Cumplimiento, que se realizará en el día de mañana. Pero hoy ese mismo tema nos permitirá recibir la presentación de estos candidatos, que se hará a través de un conjunto de videos confeccionados por ellos mismos y remitidos a la Secretaría. Para llegar a esta reunión, la mesa directiva ha desarrollado un conjunto de actividades intersesionales, de las que muchos de ustedes han sido ciertamente protagonistas. Como ustedes saben, la mesa directiva está prevista en las reglas de procedimiento de la COP que aprobamos en la decisión 1.1 de la Conferencia de las Partes de la primera reunión que se celebró en Santiago el año pasado. Está integrada por una presidencia, en este caso le corresponde a mi país, a Uruguay, y 4 vicepresidencias, la de Antigua y Barbuda, Argentina, México y Santa Lucía. Además de un representante del público que participa activamente también en las reuniones. Estos integrantes permaneceremos en funciones hasta el final de la segunda reunión ordinaria de la Conferencia de las Partes del año próximo, en la que tendremos oportunidad de elegir a los nuevos miembros. La principal función de la mesa directiva es la de velar por el cumplimiento de las decisiones adoptadas por la COP. Por tanto, desde abril del año pasado y hasta estos mismos días, estamos plenamente ocupados de dar cumplimiento a todas las decisiones adoptadas en 2022. Para ello mantuvimos 9 reuniones virtuales, 5 durante el año 2022 y 4 en lo que va del año 2023. Hace apenas 2 años que nuestro acuerdo se encuentra en vigor. Y realmente es un desafío, pero también es un gran paso que en esta reunión podamos lograr la integración plena del Comité de Apoyo a la Aplicación y la Implementación del Acuerdo. Para ello se ha seguido un procedimiento de convocatoria, recepción, análisis y selección de las postulaciones según lo previsto en las reglas de composición y funcionamiento aprobadas en la decisión 1.3 de la primera reunión de la Conferencia de las Partes. Aún así, es evidente que no todos los aspectos pudieron estar detenida y detalladamente incluidos en las reglas. Ninguna norma puede prever todos los detalles, ni siquiera sería bueno que así sucediera. Esta mesa directiva, por transitar la primera elección de miembros del comité, debió ser creativa y de alguna manera inspirarse en otros ejemplos de otros acuerdos internacionales para transitar este procedimiento de la mejor manera, con transparencia y con la significativa participación del público, para dar garantía a todos los estados parte acerca del resultado. Del medio centenar de postulaciones recibidas, tuvo en primer lugar que seleccionarse siguiendo los requisitos dirimentes, aquellos que las reglas de composición y funcionamiento establecían como condiciones esenciales para poder ser miembro del comité. Entre ellos, ser independiente de los poderes ejecutivo, legislativo y judicial de cualquiera de los estados parte. Hecha esa primera selección, la mesa directiva pasó a una segunda etapa en donde debió seleccionar de la lista resultante una lista corta, que las reglas denominan lista numerada, que no puede contener más de 10 personas. Eso se hizo siguiendo los criterios también previstos en las reglas, especialmente los criterios de igualdad de género, el criterio de distribución geográfica equitativa, el criterio de conocimientos y experiencia jurídica, pero también aspectos que la mesa y los países miembros valoraron como relevantes. Por ejemplo, un cierto equilibrio en las personas integrantes del comité entre los estados parte y los estados no parte, todos ellos integrantes de la región de América Latina y el Caribe, evidentemente. Lo que tienen ustedes ahora a disposición, esta lista numerada por orden alfabético, es el resultado de este proceso. Hay que decir que fue un proceso difícil, porque todas las postulaciones tenían gran valor. Y va a ser difícil nuestra selección, porque la lista de 10 candidatos es realmente de una riqueza y valor que de ninguna manera queremos perder. Las propias reglas de funcionamiento nos dan la posibilidad, porque si bien vamos a elegir 7 miembros, llamémosle titulares para el comité, las propias reglas prevén que los otros 3 integrantes de la lista corta, que no sean electos, se mantendrán en esa lista para el caso en que se produzca alguna vacante entre los 7 titulares, porque el llenado de esa vacante, según las reglas, debe realizarse recurriendo a los 3 miembros restantes de la lista numerada. Son 3 personas que no van a ser electas mañana, pero que mucho nos gustaría que siguieran vinculadas a nuestro acuerdo, que siguieran relacionándose con los derechos de acceso, que siguieran en sus actividades que los llevaron a estar en esta lista, porque en cualquier momento podría ocurrir la eventualidad de que requiriéramos de su participación y asistencia. La mesa ha tenido otras actividades en este periodo intersesional derivadas de las propias resoluciones de la primera conferencia de las partes. En especial se realizó la elección de los representantes del público y hoy se van a presentar a esta reunión los 6 representantes electos por el sistema de elección con el que cuenta el Acuerdo de Escazú, con lo cual tenemos 6 representantes electos de forma democrática, de forma abierta, de forma transparente y en una edición que no es la primera vez que realizamos, pero que sí tiene carácter ejemplarizante desde muchos puntos de vista. De la misma manera, la mesa organizó y apoyó el funcionamiento del grupo de trabajo en materia de defensores de los derechos humanos en asuntos ambientales y organizó el primer foro anual correspondiente al año 2022 que se realizó en octubre del año pasado en la ciudad de Quito, en Ecuador. Algunos de esos resultados podremos tenerlo en las sesiones especiales que hemos previsto dentro de esta reunión, específicamente en la que se realizará el día de mañana. Pero claramente este es un tema que nos acompañará, es un tema de prioridad y trascendencia para el acuerdo que estará presente en nuestras próximas reuniones de carácter ordinario. Evidentemente, tenemos confianza. Creemos que están dadas las condiciones para que esta reunión sea un éxito. El esfuerzo que ha puesto la República Argentina en la organización está a la vista. Son muy positivos. La Secretaría ha puesto un esfuerzo muy grande en este trabajo de innovación, de desarrollo que hemos llevado en pleno verano del sur para que esta reunión fuera exitosa. Faltamos nosotros. Cada uno de nosotros tenemos ahora que aportar para que los acuerdos se alcancen, para que los consensos sean posibles y para que esta reunión implique una vez más una señal política de trascendencia acerca de la necesidad y la vigencia de los derechos de acceso en nuestra región. Estoy seguro que eso va a suceder. Nosotros estamos orgullosos de poder acompañarlos, de poder brindarnos a los estados parte, a los estados signatarios y al público. En esta oportunidad hemos propuesto a la mesa la posibilidad de ceder la presidencia de la reunión a la vicepresidencia de Argentina, que como país anfitrión ha organizado y va a dirigir nuestros trabajos hacia la finalidad y hacia el éxito que esperamos. De manera que pido concluir mis palabras con el reconocimiento a Cecilia y a su equipo y a la vicepresidencia que ejercerá en estos días para todos nosotros a través de un fuerte aplauso. Muchas gracias.
Muchísimas gracias a la Presidencia y quisiera ahora invitar a Cecilia Nicolini, Secretaria de Cambio Climático, Desarrollo Sostenible e Innovación de la República de Argentina, que en calidad de anfitrión y en próximos minutos presidencia de esta reunión nos dirija unas breves palabras en la apertura. Adelante, Cecilia.
Bueno, muchísimas gracias, Carlos, Marcelo. Muy buenos días a todos y a todas acá. Como dijimos ayer, es una enorme alegría de contar con todos y todas ustedes que han venido de casi todos los rincones de América Latina y el Caribe. No quiero extenderme mucho porque bueno, ayer tuvimos una jornada interesante en la apertura. Hacer eco sobre todo de las palabras de Marcelo. En primer lugar, agradecerle muchísimo a Uruguay y sobre todo en su persona por el extraordinario trabajo que están llevando adelante desde la presidencia de la mesa directiva. Para nosotros y nosotras, y esto es un trabajo colectivo desde la Argentina, la veo a mis colegas de Cancillería, Corina, Jessica y a todo el equipo, creo que es un enorme orgullo poder presidir esta segunda conferencia de las partes extraordinaria y hacerla extraordinaria también. Creo que ese es el gran compromiso que tenemos. Del mismo modo, agradecerle muchísimo también a la CEPAL por la enorme labor que vienen haciendo ya hace muchísimos años, pero ahora específicamente en la coordinación también de estas conferencias, y no solamente lo que ven hoy acá es lo que sucede. Todo esto viene de muchísimo trabajo de días, horas, semanas, fines de semana, no solamente para lo que es la organización del encuentro, sino también para todo el trabajo que significa realmente la implementación del Acuerdo de Escazú. Y creo que eso es lo más importante y lo que nos tiene que guiar estos días. También quisiera destacar el apoyo y el acompañamiento, y creo que no es un punto de llegada, sino un punto de partida en todo lo que tenemos y que podemos trabajar en conjunto, específicamente con la CAF, el Banco de Desarrollo de América Latina, que hizo posible este encuentro, y estoy segura, ya lo escuchamos de las palabras de su vicepresidente, que va a ser un gran aliado para que Escazú pueda seguir avanzando y pueda seguir sumando a lo largo y ancho de toda la región. También agradecer al PNUD, al Programa de las Naciones Unidas para el Desarrollo, seguramente estará por ahí Maru Di Paola, que es una aliada incondicional, no solamente aquí desde la oficina de Argentina, sino también a nivel regional, siempre nos acompañan. También al PENUMA, otro gran aliado, lo veía esta mañana, ahí lo veo a Alberto Pacheco también, un gran amigo de la casa y que siempre disponemos de su apoyo y colaboración para todas las actividades. Al Banco Mundial, que nos está ayudando también con algo fundamental, que es la implementación de nuestro acuerdo a nivel nacional y que también se siga sumando a todas las actividades. Como dijimos ayer, esta COP extraordinaria expresa la voluntad que todos y todas asumimos en la primera conferencia en Santiago de Chile, cuando todavía estábamos en un mundo, siguiendo las palabras de ayer que nos recitaron de un querido también uruguayo, Eduardo Galeano, patas arriba. Estábamos todavía transitando la pandemia y fue un gran esfuerzo poder hacer esa primera conferencia en formato presencial, medio híbrido. Chile con ese gran esfuerzo que estaba haciendo para ratificar el acuerdo y finalmente pudimos celebrarlo en esta conferencia y realmente sentó las bases para lo que estamos trabajando. Y creo que ahí convenimos entre todos y todas que no podíamos esperar 2 años para volver a encontrarnos y avanzar con todo lo que tenemos que hacer de aquí por delante. Y como ayer mencionábamos, creo que en este momento tan complejo, no solamente a nivel regional, sino también a nivel global, hay un punto fundamental que quiero destacar y creo que todos y todas estamos de acuerdo, que es la necesidad de integrarnos como región, la necesidad, ese compromiso que sabemos que juntos llegamos mucho más lejos. Y a pesar que muchas veces políticamente vivimos en esto que llaman a veces mis colegas los politólogos el péndulo, y a pesar de que los gobiernos vayan cambiando y tengan una posición u otra, creo que el gran trabajo y la gran fortaleza que tenemos en el acuerdo de Escazú es contar con la participación del público, contar con la participación de ciudadanos y ciudadanas, de organizaciones, que los veo aquí presentes esta mañana, que sea el compromiso y las ganas que tenían por participar también de esta conferencia y que de alguna manera van a ser también garante que este acuerdo siga avanzando y que los que somos los estados parte sigamos cumpliendo con nuestras obligaciones y nuestros compromisos más allá de los cambios de gobierno que se presenten. Y creo que esto es una herramienta y una ventaja fundamental, así que hay que aprovecharla. Nos esperan un montón de debates estos 2 días y de trabajo en conjunto. Como bien decía Marcelo, tenemos un aspecto fundamental y ya estamos, creo, en proceso de elegir a el comité de expertos y expertas para ayudarnos a cumplir con este acuerdo, a hacerlo efectivo. Ese es el objetivo principal de esta conferencia, pero también hemos hecho lugar para debatir cosas que son fundamentales. Una urgencia que tenemos que seguir trabajando. Sobre todo hay muchísimos países que es el punto número 1, creo, en la agenda, que es el plan para proteger a los defensores y defensoras ambientales de nuestra querida América Latina y el Caribe, que siguen viendo amenazado su integridad física, moral, económica, territorial, y creo que esto es un compromiso y un deber moral y uno de los grandes objetivos que tenemos en esta conferencia, así que seguir avanzando con ese plan. Y lo tercero, y que ayer mencionábamos, como sabemos, para poder implementar todas estas hojas de ruta, estas estrategias que vamos a estar debatiendo, necesitamos los mecanismos de implementación, los medios de financiamiento para que eso pueda ser posible y que podamos llevar los planes y lo que discutamos realmente al territorio, que es ahí donde vamos a hacer la gran diferencia y donde realmente las decisiones que podamos tomar acá sirvan para cambiar la vida de la gente, que es en definitiva para los que nos reunimos acá y quienes creemos que la política es una herramienta transformadora, seguimos apostando para que sea así. Así que bueno, sin más, creo que Escazú, como dijimos ayer, nos marca un camino para debatirnos cómo queremos que sea el desarrollo sostenible de nuestra región en las próximas décadas, de ahí su gran importancia. Y esperamos que esta conferencia, como decía al inicio, sea extraordinaria en todos sus sentidos y que quede en la historia de este gran camino que es el Acuerdo de Escazú, marcando la diferencia y avanzando en todos los desafíos que tenemos que resolver para nuestra querida América Latina y el Caribe. Así que una vez más, bienvenidos y bienvenidas, y nos deseo un gran trabajo por delante estos 2 días. Muchas gracias.
Gracias, Cecilia. Y para concluir esta apertura, quisiera dar las palabras a Irene Murillo, representante electa del público, que además es el punto focal en la mesa directiva. Adelante, Irene.
Muchas gracias. Muy buenos días. Un cordial saludo a todas las personas presentes hoy acá en esta sala y las que nos están siguiendo en el web streaming y las otras opciones de seguir la reunión. Especialmente un saludo para todas las personas y organizaciones representantes del público y a los estados presentes, las delegaciones de los estados, de las organizaciones internacionales y prensa. Quiero hacer un agradecimiento también al Estado argentino por recibirnos acá en Buenos Aires y a la mesa de la Secretaría por todo el esfuerzo de organización que ha implicado esta reunión. Me han pedido que dé un reporte de las actividades del público y de antemano me disculpo porque sé que voy a dejar cosas por fuera. Pero quería hacer, antes de entrar en detalle, un par de precisiones. El Acuerdo de Escazú se ha logrado con base en el trabajo del público en colaboración con los estados. Eso ha sido una constante desde el inicio de las negociaciones y continúa siendo así. Así es que este es el reporte de un trabajo colectivo. Un trabajo que inicia desde los territorios, pasando por las redes nacionales, subregionales y regionales. Un trabajo de hormiga que es un trabajo poderoso que se hace desde el público. Así es que espero en este reporte poner en valor toda esa constancia de las personas y organizaciones del público que se han integrado a este esfuerzo de Escazú. Tenemos entonces la responsabilidad y el honor de transmitir a ustedes hoy la voz de toda esa labor. Hemos iniciado nuestra función como segundo equipo de personas representantes del público en noviembre pasado. Estamos empezando un periodo de 4 años en el que manifestamos desde ya toda nuestra apertura y nuestra disposición de trabajar en colaboración y de tender puentes con todos y todas ustedes. Nos hemos unido desde el inicio de nuestra gestión al trabajo en el Grupo Especial de sobre personas defensores de derechos humanos ambientales. Hemos también acompañado a la mesa directiva en su gestión. Hemos hecho un trabajo de divulgación y de educación sobre el acuerdo muy fuerte, y aquí reitero nuevamente también nuestra disposición de apoyar a los grupos que así lo requieran. Y en relación con el mandato de la Conferencia de las Partes para esta COP extraordinaria, hemos estado apoyando desde el inicio el proceso que nos lleva a tener hoy la posibilidad de elegir a las personas miembros del Comité de Apoyo a la Aplicación y Cumplimiento. El público ha dado un seguimiento a esto. Hemos tenido una reunión con más de 100 personas participantes para discutir las 48 candidaturas recibidas que fueron estudiadas y analizadas de una manera profunda, y queremos continuar apoyando ese proceso para que en esta conferencia tengamos un comité excelente, que la lista corta de 10 personas presentada lo es, así es que tenemos toda la confianza de terminar con gran éxito esta reunión. Las organizaciones del público han estado también fuertemente trabajando en los temas de implementación del acuerdo en los países parte, a través de gestiones administrativas, judiciales, a través de el trabajo de seguimiento, de levantamiento de una línea de base de la situación de los países, y de acompañamiento para lograr avances. Han estado y continúan trabajando muchísimo en la divulgación y en la educación sobre el acuerdo. En las solicitudes y presentación de documentación a sus estados y al propio acuerdo para hacer ver las posiciones y las ideas del público que consideran importantes. Han estado trabajando y hemos estado trabajando por las ratificaciones y por las firmas con el fin de incluir cada vez más estados en este acuerdo. La meta son los 33 países de la región. Y llevando la discusión, sobre todo, a los grupos y a las organizaciones que están en los territorios. Yo quiero hacer público un agradecimiento a todo ese trabajo que se está realizando en cada uno de los países de la región. Nada más para finalizar, esta es nuestra primera COP como equipo de representantes del público y manifiesto nuevamente acá nuestra apertura al recibir la retroalimentación y las recomendaciones que ustedes quieran dar a este equipo. Estamos a la orden y muchas gracias.
Muchas gracias, Irene. Con estas palabras concluimos la apertura y, como bien ha dicho la presidencia, con don Marcelo, la presidencia está cediendo la conducción de esta reunión a la vicepresidencia de Argentina en su calidad de país anfitrión. Así que procedemos al traspaso formal de la presidencia. Invitamos, por tanto, a Irene y a Marcelo a tomar sus respectivos asientos y con esto empezaríamos el segmento oficial de la COP con la revisión del temario. Así que, presidencia, a partir de ahora tiene usted la palabra.
Bueno, muchísimas gracias. Vamos a dar entonces paso a los aspectos de organización de esta segunda conferencia de las partes. Y como bien decía la Secretaría, corresponde ahora considerar el temario provisional. Muy bien. Como recordarán, en la decisión 1/5 de la COP1 se estableció que esta COP extraordinaria tendría por objetivo elegir a las y los integrantes del primer comité de apoyo a la aplicación y el cumplimiento y conocer cualquier otro asunto que las partes aquí presentes decidan. Les recuerdo también que la regla de procedimiento de la COP 5.5 establece que el temario de una reunión extraordinaria comprenderá únicamente los temas propuestos para su examen por la conferencia de las partes en una reunión ordinaria o en la petición de convocatoria de una reunión extraordinaria. Y el temario se distribuirá a las partes al mismo tiempo que la invitación a participar en la reunión extraordinaria. Dando cumplimiento a esta regla, tienen ante ustedes, creo que lo tienen todos, ¿no?, en el escritorio, el documento LC/COP-EZ.2/1, el cual consta de 4 puntos. El primero son los aspectos de organización, que incluyen la aprobación del temario provisional, las credenciales de los estados parte. El segundo punto es la elección de las y los integrantes del Comité de Apoyo a la Aplicación y el Cumplimiento del acuerdo. El punto 3 corresponde a otros asuntos y el punto 4 a las decisiones aprobadas. Si no hubiera comentarios de aquí de los y las presentes, procederíamos a aprobar el temario. Bien, no observando objeción alguna, se da por aprobado el temario. Continuamos. Como saben, esta conferencia de las partes es el máximo órgano deliberativo del acuerdo de Escazú, establecido en virtud de su artículo 15. Corresponde a la conferencia de las partes examinar y fomentar la aplicación y efectividad del acuerdo y ejercer las funciones que mandata el tratado. Y para ello aprobará las decisiones que estime convenientes. Sobre este particular, habida cuenta de que esta conferencia es extraordinaria, las delegaciones tienen ante sí un único proyecto de decisión para consideración de esta conferencia, el cual constituye el eje central de esta COP. Y es el proyecto de decisión 2/1, elección de integrantes de Comité de Apoyo a la Aplicación y el Cumplimiento. Asimismo, será sometido a consideración un proyecto de declaración política. Todos estos borradores están disponibles en la web de la conferencia. Cualquier consulta o dificultad para acceder, por favor, háganoslo saber. Para poder considerar adecuadamente lo anterior, la organización de los trabajos ha dividido la consideración del punto 2 del temario provisional en dos partes. Una presentación de la lista corta de candidatos al Comité de Apoyo a la Aplicación y el Cumplimiento por parte de la mesa directiva en el día de hoy, y la elección de las y los integrantes en el día de mañana. De manera complementaria, se han organizado 3 sesiones especiales y un diálogo regional. Las sesiones especiales versarán sobre los siguientes asuntos: experiencias comparadas de órganos de apoyo a la aplicación y el cumplimiento, seguimiento a la decisión 1/6 sobre defensores y defensoras de los derechos humanos en asuntos ambientales y seguimiento a la decisión 1/4 sobre arreglos financieros e informe del Fondo de Contribuciones Voluntarias. En cuanto al diálogo regional, tendrá como objetivo fortalecer las capacidades para la implementación nacional. Les invito a revisar el programa de la reunión, donde se encuentran consignada la información de cada una de estas sesiones complementarias. Y antes del cierre de la COP, el día de mañana será lectura al conjunto a los textos que fueron aprobados, los cuales serán incluidos en un anexo al informe oficial de la reunión. Quisiera también hacerle notar a las delegaciones que para aportar mayores antecedentes sobre cada punto del temario, la Secretaría ha puesto a disposición un temario provisional anotado, consignado en el documento LC/COP-EZ.2/2, disponible también en la página web de esta conferencia. A continuación, nos corresponde considerar las credenciales de los estados parte y recibir el informe de la Secretaría. La regla de procedimiento 6.3 de la Conferencia de las Partes establece que las credenciales de representantes y los nombres de representantes suplentes y personas asesoras deberán comunicarse a la Secretaría sin demora alguna hasta 48 horas antes de la inauguración de la reunión. Cualquier cambio posterior en la composición de la delegación también deberá comunicarse a la Secretaría. Las credenciales deberán ser expedidas por la jefa o jefe de Estado o de Gobierno o por la ministra o ministro de Relaciones Exteriores. Para asistir a las partes en el cumplimiento de este requisito, la Secretaría publicó un modelo de credenciales apropiadas. De conformidad con la regla de procedimiento 6.4, la mesa directiva examinará las credenciales y se presentará su informe a la conferencia de las partes. Se invita entonces a Santa Lucía a presentar el informe sobre las credenciales en nombre de la mesa directiva.
Thank you very much, Madam Chair. Host country Argentina, its government and people, officials from the Escazú Secretariat, presiding officers, fellow delegates from the member states of the Escazú Agreement, newly elected representatives of the public, distinguished nominated candidates for the Committee to Support Implementation and Compliance, the media, international organizations, other invited persons, ladies and gentlemen, good morning. On behalf of the presiding officers and St. Lucia as one of the vice chairs, I have the pleasure to provide the report of credentials for COP2, an extraordinary meeting pursuant to Rule 6.4 of the Rules of Procedure. After examining the credentials submitted by the parties as of 20th of April 2023, which is today, the representatives of all parties registered to participate have submitted copies of credentials issued either by the head of state or by the government or by a minister for foreign affairs. Delegations are requested to submit originals to the Secretariat as soon as possible. The Conference of Parties is invited to take note of this oral report. I thank you very much, Madam Chair.
Thank you. Bueno, no habiendo objeciones, solicitamos a la Secretaría lo consigne en el informe de la reunión y ahora sí pido a la Secretaría del Acuerdo de Escazú que continúe con el informe de actividades.
Muchas gracias, Presidencia. La Secretaría de la CEPAL, básicamente en este periodo, desde la COP pasada hasta la presente, se ha enfocado en tres actividades principales. Una, y muy importante, y como se demostró en la celebración que tuvimos ayer, en avanzar en los procesos y ayudar a las futuras partes a integrarse en el Acuerdo de Escazú. Como todos tenemos claro, para la Secretaría y para todas las partes asistentes, uno de los elementos centrales, y para el público, por cierto, es que los 33 países de América Latina y el Caribe sean parte del Acuerdo de Escazú, con lo cual ese ha sido uno de nuestros esfuerzos y, por supuesto, tendemos la mano al resto de los países que no son parte para contar con la Secretaría en todo ese procedimiento, incluido las conexiones con la Oficina de Tratados de Naciones Unidas en Nueva York. Los otros dos elementos centrales para la labor de la Secretaría tienen que ver con las propias labores de Secretaría y las organizaciones que don Marcelo Causillas ha mencionado muy bien como reporte de la mesa directiva y que complementaré posteriormente. Y el tercer elemento, que es un elemento central, es el reconocimiento de que el Acuerdo de Escazú es un acuerdo de fortalecimiento de capacidades y cooperación y, por tanto, la Secretaría ha trabajado en ese fortalecimiento de capacidades y en esa cooperación, que es la herramienta principal para el cumplimiento del acuerdo. Respecto de los procesos de adhesión o ratificación, obviamente ya conocimos los tres nuevos países parte, hay varios que están en camino y esperamos que para la próxima conferencia de las partes seamos más en esta familia. Varios de los observadores aquí están en procesos muy avanzados que esperamos concluyan. Respecto de los temas de los procesos propios de la Secretaría, durante este año, como pueden haber dado cuenta, el elemento principal ha sido el procedimiento para la elección de los miembros del Comité de Apoyo a la Aplicación y Cumplimiento. Para eso hicimos un llamado a la publicación de candidaturas que duró desde el 15 de septiembre al 15 de diciembre. Se apoyó a la mesa directiva en esa preparación de la lista numerada con el análisis de todas las candidaturas y un procedimiento de revisión con ellos y también con la participación de los representantes electos del público. Y el 8 de la lista numerada se publicó ocho semanas antes de la apertura de la COP, tal y cual como está establecido en las reglas de procedimiento, es decir, el 23 de febrero. Ahí es importante mencionar que tuvimos 48 candidaturas admitidas de 15 países de la región. Muchos países de la región, varios países de la región tuvieron varios muy buenos candidatos y, como recordarán por las reglas, solo puede ser elegido un miembro del comité de cada país y, por lo tanto, eso fue una de las restricciones. No voy a entrar en los candidatos porque tendremos a bien discutirlos con ellos. El otro elemento importante en esa preparación de esta COP fue la organización de la pre-COP, que fue, como ustedes recordarán, en formato virtual el 6 de marzo del 2023. Su objetivo fue precisamente dar la oportunidad a los 10 candidatos a que se presentasen y tener un diálogo con ellos. La grabación de la reunión está disponible también en la página web, así como todos los antecedentes de todos los candidatos que se presentaron. También hay disponible en la página web, tanto de la pre-COP como de la COP, el informe de la conferencia de las partes, que es el documento LC pre-COP EZ.2/1. Con ello pueden ver los diálogos que se mantuvieron, y en esa pre-COP es importante destacar que también se informó de toda la agenda que íbamos a tener en esta conferencia de las partes, se informó también del temario y, por supuesto, se informó de los procedimientos de registro para la participación de todas las personas. Respecto de esta segunda conferencia, que también hemos organizado, pero en realidad la Argentina ha sido quien ha liderado todo con un equipo extraordinario de Cecilia y de la Cancillería, estamos en ella. Marcelo ya explicó un poco las cifras, pero sí quería destacar que 2/3 de las personas registradas son del público. Para la Argentina y para la CEPAL y para los representantes del resto del público y para todas las partes, el que pudiese participar la mayor cantidad de gente ha sido una prioridad. Como ustedes saben, en la COP de Escazú los requisitos son muy pocos. Son registrarse, la única limitación es el aforo que tenemos por disposición. Dicho esto, como bien explicó don Marcelo, el éxito de Escazú ha hecho que las peticiones de registro hayan sido muy superiores, pero ahí con la ayuda de la Argentina establecimos 2 salas de aforo. Están en el piso superior de sobreaforo para que se pudiese seguir la reunión, tanto la prensa como el público. Y establecimos un sistema que obviamente tiene imperfecciones y que con la retroalimentación del público esperamos mejorar, donde tratamos de mantener en lista de espera a todas las personas, y agradecemos desde ya a todas aquellas que no pudieron venir, que avisaron a la Secretaría. Eso hizo que un 20% más de personas del público pudiesen ser registradas con posterioridad gracias a las personas que avisaron que no iban a venir. Sin embargo, como siempre, ha habido restricciones. También mencionar que del público el 40% de los que se registraron fueron de la República de Argentina. Las delegaciones ocupan apenas un 20% del aforo, organismos internacionales un 13% y la prensa un 6%. Hay 40 medios acreditados para reunir este evento. Y, por supuesto, tuvimos además 22 sesiones virtuales que están funcionando desde ayer en la mañana, muy temprano. También durante el año hicimos 9 sesiones con la mesa directiva, preparamos la página web, ojalá puedan seguir la página web. La página web de la conferencia tiene también el link para la transmisión de web streaming. Como ustedes saben, desde que comenzamos Escazú en el 2012, todas las reuniones se transmiten, son completamente transparentes. El otro elemento fundamental, como les decía, es apoyar a las partes en los procesos de implementación nacional. Tenemos una sesión en la tarde. La CEPAL está apoyando ya a varios países, primero en discusión con ellos en establecer una hoja de ruta para establecer esos planes de implementación nacional, pero luego con la ayuda de otros socios y obviamente bajo el liderazgo de los propios países, a avanzar precisamente en esas hojas de ruta para
to have an annotated index and an action plan to be considered and adopted in the third conference of the parties to be held next year. The first annual forum was very successful. It was organized in Ecuador, in Quito, over 220 in-person attendees and hybrid attendees. There were 10 working groups that received 101 proposals to be included in the action plan. There's also an available report for you to follow up on what happened there. Regarding the other element that we supported was the election of the newly elected representatives of the public. This entailed designing the electoral roll, the procedures for the candidatures, and to conduct the election. For that, we had 72 candidates from Latin America, 58 submitted their candidatures within the timelines adopted, and 32 were men and 28 men and 32 women. And they accompany us in this Conference of the Parties. This process improved, and we created a participation platform. All of you who were involved in voting know it. This platform was developed thanks to the Ford Foundation support, so the public will have a communication tool that is more participatory rather than our standard and traditional mechanism. From now on, we'll be able to have higher interactions, and on Friday, will use it to receive the feedback to devise the national implementation plan. The public regional mechanism has grown. There are over 9,000 people registered there. Countries, we can know who is participating there. Mexico has the leadership there. It has exceeded the colleagues of Argentina. Mexico, Argentina, Chile are the countries that have more people registered in this mechanism. In relation to the population, Antigua and Barbuda still leads the number of registered people. It's important for you to follow up our website because we upload all the information there, allowing us to tell you about our advances and all the mechanisms for participation. To conclude, I want to highlight the dissemination work done, and the Principle 10 Observatory has been a key point for cooperation in terms of legislation, advance on treaties, jurisprudence, new acts that are being enacted. And I want to highlight that that observatory has the highest number of visits. We have over 3 million sessions registered, and that observatory is the result of a work of all of us. We have received new jurisprudence, regulatory aspects, and through that observatory we make some interesting posts to solve Escazú-related topics, and newsletters in English and Spanish. They've been 4 since the last COP. In the postings or posts, we focus on the implementation guide for the Escazú agreement, and we started implementing action plans, and during the afternoon we'll see some of the outcomes. We have created some nice infographics, Escazú with biodiversity, for the Conference on the Parties on Biodiversity. With that, I think that this covers the report of the Secretariat, and of course everything that I have said will be expanded or further developed in the remaining sessions.
Thank you very much. I'm I hear we're speaking very, very quickly, and it's difficult for the sign language and for the interpreters, our dear interpreters. So we'll have to slow down a little bit. But we've concluded this segment, and now it's the time to look into the second item on the agenda. And this would be the presentation of the roster of nominees to the Committee to Support Implementation and Compliance by the presiding officers. As we said, the Secretariat, in line with the rules of composition and function of to support the presiding officers, put together a list to be considered by the Conference of the Parties, and we shall try to choose and elect these people, as we've heard, with consensus, by consensus. There not being consensus, this Conference of the Parties will have to elect them by simple majority of the parties present here at and with the voting right. This will be a secret ballot, and I understand it would take place tomorrow. As we've already mentioned, the people forming part of the committee will be elected for a 4-year term. The mandate can be extended for another 4-year period or term, and the mandate of the members of the committee begins at the end of the session of the Conference of the Party where they've been elected. So if we do so, that would be immediately after this COP concludes. We should also mention, this has been said by the Secretariat, that 3 of the people elected in the first election will have a term of office for 6 years. And immediately after the first election, the chair of the Conference of the Parties will appoint, will draw the names, and the people will have a 6-year term of office, contrary to the rest. All the delegations have the roster for the nominees to the committee that was put together by the board presiding officer, which is published in lz/cop-ez.2/ddr/1, dated February 23, 2023. Such list, and I'd like to stress this, is formed by 5 men and 5 women, respecting gender parity, with 10 nationalities of countries listed in Annex 1 to the agreement. 3 representatives come from Central America and Mexico, 3 from the English-speaking Caribbean, and 4 from South America. This was 5 states party and 5 states non-state parties. Currently, it would be 6 states party and 4 non-parties. And now I'm going to mention the names one by one. In the order is an alphabetical order, and they are the following people: Guillermo Eduardo Acuña from Chile, Mariana Blengio Valdés from Uruguay, Rubens Harry Bourne from Brazil, Juan Carlos Carrillo Fuentes from Mexico, Rita Leonette Joseph Olivetti from Grenada, Patricia Madrigal Cordero from Costa Rica, Gavin Sherva Mitchell from Trinidad and Tobago, Andres Maria Napoli from Argentina, Carol Denise Angela Stevens from Jamaica, and Felix Wing Solis from Panama. The delegations had the opportunity of getting acquainted with these 10 nominations at a preparatory meeting, it was the pre-COP, and I understand this was held on March 6th this year. That was done online, and the report to that is also posted in document LC/PCOP-EZ.2/1. This document also posted on the website. May I remind you all that the process to set up the roster, as we will do shortly, to start the election process of the members of the first committee, the Secretariat published the requirements for nominations to the committee on September 15, 2022 last year, and those requirements listed the criteria for nominations as well as the procedures for nomination and election as set forth in the rules of composition and functioning of the committee. The requirements included an affidavit and form for nomination. The term was 3 months, concluding on December 15, 2022 at 11:59 p.m. Santiago time, and we got 49 nominations from 15 countries in Latin America and the Caribbean. Of these, 48 were admitted. One was not admitted because it wasn't filed timely, and all the nominations were published on January 19, 2023 on their website of the Escazú Agreement. In order to facilitate the revision and review of candidates accepted, the presiding officer requested the Secretariat to put together a form with the nominations with the following fields: name, country of nationality, country of residence, gender, age, complying with the independence criteria, which was very important, let me tell you, expertise in public agency, current position they hold, competence as to rights of access and Escazú Agreement matters, expertise of legal matters, academic degrees, years of pertinent experience, compliance of the moral integrity criteria, availability regarding their times, languages, information on traveling and assistance, and pertinent publications. With this, the presiding officers reviewed all this in detail, and as to the form and the requirements of the criteria regarding the functioning, and we also considered additional criteria such as expertise in legal affairs and years of experience, as we mentioned already. Besides, as mentioned, something that drew our special attention was not just gender parity, but also geographical distribution needing to be equitable. I think that is very important. We try to stick at it when we appoint Escazú bodies. And finally, we considered the restrictions as to the committee rules, in view of which there could not be at that committee more than one person of the same nationality. This guarantees greater diversity. In turn, the presiding officers invited the elected public representatives of the public to participate in a meeting where they were asked as to the roster prior to its preparation, in order to take all these details into consideration at the time of putting forward this roster here today at the Conference of the Parties. As you all know, we have not anticipated participation in person of the candidates at this conference, or at least in the official segments of the COP. So we have allowed for their participation. We talked it over at the presiding officers to be present yesterday, which indeed happened, and also the different activities in regard of this conference in the adjacent rooms, such as associate events of the Conference of the Parties, so that they could all be involved in them. So we requested the candidates to present a short video with their presentation that will be available and that we will hear and see in a moment. To conclude, upon the request of the presiding officers, the Secretariat requested candidates on April 19, 2023, to reconfirm their nomination and their availability for their eventual election and performance or filling in that position, as well as the continuity of the compliance of the requirements established, mentioned previously. And let me tell you all that we've got confirmation in every case regarding both aspects and regarding everything involving the nominations. So if you consider it fit, it is time for the videos, and we will go on to hear that. Good morning. I am Guillermo Acuña. I am one of the 10 candidates who wish to form part of the committee to support the implementation and compliance of the Escazú Agreement. I'd like to take advantage of this opportunity to greet the countries, the representatives of the public, and the observers present at the second Conference of the Parties to the Escazú Agreement in the city of Buenos Aires. I have 34 years of work experience, which I have listed in detail in the conference annexes and in the pertinent documents. However, now I'd like to focus on 3 or 4 features that may prove particularly relevant upon the countries deciding who shall form part of the committee. In the first place, there's my experience on law enforcement and compliance, all along different projects, whether binational, sub-regional, or regional projects, specifically on law enforcement and compliance, as well as my experience at OECD ECLAC environmental performance reviews in several countries of this region, also underscoring law enforcement and compliance. In the second place, I'd like to make visible and put forward my experience on intergovernmental matters, which has enabled me to get acquainted with rules, procedures, ways of going about things in intergovernment agencies, specifically treaty bodies, and within this framework, the principle of subsidiarity that the Escazú Agreement vests on the committee. In the third place, how very much acquainted I am with the history of the Escazú Treaty and its origins, right from the beginning in 1992, after the Johannesburg Summit, right up to its negotiation and the signature and ratification process. And in the fourth place, may I highlight, based on the principle of cooperation guiding the agreement and translating into its true spirit, my experience on training, on rights of access in the region, which I built upon during quite some time. I think all this might prove interesting to the countries upon deciding and making a decision. And now I wish you every success in the deliberations in Buenos Aires. Hello, I'm Mariana Blencio from Uruguay. It is an honor to be here at this the last instance in a fruitful dialogue open to the participation of the public, a process whose purpose is to project the capabilities of the state parties in order to promote the rights of access in environmental matters. As you all know, I am a lawyer, having specialized on human rights, an issue which I've been active at for the last 30 years, having stressed the rights of persons, their vital environment, and everything concerning the rights to live in a healthy, balanced environment. In that, carrying out that job for a long time now, I worked in the professional environment as well as in the academia, and I've had the opportunity of participating in the non-jurisdictional protection, carrying out a very interesting job, which was putting together a national report whose purpose was to project the Escazú Agreement nationwide. This report that was put together in cooperation with the civil society, with the public, in liaison with different state agencies, and of course, in a very fruitful dialogue with ECLAC, was a benchmark, a national benchmark, and also a regional Latin American and Caribbean benchmark. I understand that impartiality, independence, and honesty are essential qualities for all those that will form part of the committee to support the Escazú Agreement, an ethical imperative that I pledge to fulfill, considering in turn that it is a true honor to join in the efforts to generate and project participation, information, and justice, and in short, respect a process recognizing the integration of humans and natures. To conclude my brief presentation, I'd like to highlight the relevance of this historic conference, which is a way of celebrating the kickoff of the Escazú Agreement, which, with profound regional roots in the Americas, promotes peaceful dispute settlement, prevention of conflicts, good governance, and all those elements that will be instrumental to a clear and transparent accountability, always bearing in mind the human being and his and her environment in its integration with nature, based and focusing on human rights. Thank you very much for giving me this opportunity.
Hello, I'm Rubens Born from Brazil. I have been working on environmental issues, promotion of democracy, and public participation for about 40 years. I've been engaged in multilateral processes and the national and local implementation of binding and voluntary international agreements for 32 years. I had the privilege of participating in the 9 negotiation sessions of the Escazú Agreement, promoting the dialogue and construction of this regional treaty. In my participation, I have relied heavily on the experience I've acquired over the past 33 years, working on the construction and implementation processes of other multilateral agreements, such as the Framework Convention on Climate Change, the Biodiversity Convention, and Agenda 21 and 2030. The Escazú Agreement is the result of an open dialogue based on the participatory construction of government representatives and civil society members. In this context, and focusing on dialogue, Escazú is a relevant milestone for action by individuals and community groups that defend human rights in environmental matters beyond the application of the 3 access rights. Escazú faces capacity building and cooperation challenges. So the support committee must work on the opportunities and conditions to address them. I consider that I'm a person committed to dialogue between the different sectors of society at the local, regional, national, and global levels. The Committee to Support the Implementation and Compliance of the Escazú Agreement must ensure dialogue as a method to assist state parties with public participation. My academic background as a civil engineer specializing in environmental engineering, as a master's and PhD in environmental public health, and later as a lawyer, helps me to understand and address the material, technical, and procedural issues for the full implementation of Escazú. I have no employment ties with institutions of the executive, legislative, and judicial branches in Brazil. I do not find any past or present reason that may question my morals and credibility to perform this role. In summary, I believe that from my professional experience and as a citizen, I will be able to make a positive contribution to the Committee to Support the Implementation and Compliance of the Escazú Agreement. Thank you for your attention and support to my nomination. Good morning. A warm greeting to all the member states of Escazú Agreement, the representatives of the public, and all the people. My best wishes for this COP2. My name is Juan Carlos Carrillo Fuentes. I'm Mexican. I'm a lawyer. I have a PhD in sustainability law and policy. I have been a public official, which helps me understand the opportunities and the limitations of the governments in the region. For 23 years, I've been working at the Mexican Center for Environmental Law, CEMDA, that is a non-profit, non-partisan civil society organization. Since then, my first project, and continues to be, rights of access in environmental matters. All along that period, I've had the chance to work with developing methodologies for government performance review methodologies with diagnosis, legal diagnosis and training sessions, and developing citizen initiatives to reform the regulatory framework And I have also developed learning material to explain the Escazú Agreement through caricatures and cartoons, thinking about rural communities. My main motivation to join this committee is that Escazú grants access to environmental justice to people, especially those who have been neglected. In all the region, there's huge inequality, discrimination towards indigenous population, gender violence, and all the people who can't read or are not used to using a computer. There are millions of people who live in vulnerable conditions, as Escazú points out. I'm particularly interested in promoting the use and preventive use of the agreement as well as an alternative dispute settlement mechanism in environmental matters, and in guaranteeing a safe environment of people who defend human rights in environmental matters, as pointed out in the agreement. I know what it's like to face a life-threatening attack for defending collective rights. It's clear that in the first generation of the committee has a responsibility to support the state parties to implement the access rights in environmental matters, and in that case to find solutions to problems that are complex and multifaceted. As part of this committee, it's very important to know the techniques and the technical, legal, and institutional diversity of Latin America and Caribbean states, by respecting the laws to think out of the box and find comprehensive solutions in advancing the Escazú Agreement. I say goodbye, and I'm very honored to be included in this roster of candidates.
Joseph Olivetti. I am from Grenada in the Caribbean. I'm a lawyer by profession and a retired judge of the Eastern Caribbean Supreme Court. As a lawyer, I have worked in Grenada for about 20 years. And as a judge, I have served in several of the states, including Tortola, Antigua and Barbuda, St. Kitts and Nevis, and Dominica. I have also acted as a judge in Belize. Recently, I have been engaged with an environmental group who is challenging several major developments taking place in Grenada. I see the Escazú Agreement as a significant development to help to attain environmental justice in Latin America and the Caribbean. The role of the committee to support implementation and compliance is a vital one, especially in these early days. I believe that my knowledge and experience will be of great help to the committee in carrying out its role to ensure that the rights and protections enshrined in the Convention are translated on the ground for the benefit of the people of the region. Thank you.
Un saludo cordial a todos los participantes de la segunda reunión de la Conferencia de las Partes del Acuerdo de Escazú.
My name is Patricia Madrigal. I have participated in the Escazú process from its inception at the Rio Plus 20 conference, and even before by working in diagnosis over the rights of access. During the preparatory process, I participated as a civil society member and during the negotiation process as Vice Minister of Environment of the Ministry of Environment and Energy of Costa Rica. And I led the delegation of Costa Rica in all the meetings of the negotiation committee from 2014 to 2018 until the text was adopted here at the Canton of Escazú. And I co-chair the presiding officers with Chile. I applied for membership to the committee to support the implementation and compliance of the Escazú Agreement because I think that I make a positive contributions to lay the procedural foundations and operational foundations that will help the working of the committee as a subsidiary body to the Conference of the Party and communicating closely with the presiding officers, and also by strengthening the meaningful participation of the public as it has been so far. I understand that the concerns of the state parties and the public should be addressed, and that a balance should be kept. We should work in the rules of procedure of the committee, but also in paying special attention to Article 9, grants the environmental human rights defenders the protection to do their work, and considering people and vulnerable groups that receive a special treatment all along the agreement. It's important to seek funding that will allow the performance of the rules as to the agreement in pursuant to Decision 1/3. I'm a lawyer specializing in public international law with an emphasis in human rights. I have a PhD in environmental law, and I have an academic background that is needed, especially with the experience of over 30 years' work in the region in human rights affairs, rights of access, and environmental rights. I firmly believe in Escazú Agreement as a regional environmental agreement that has been the result of multilateralism, and strengthening environmental democracy depends on this regional commitment. By enhancing human rights compliance, will strengthen the rule of law. My best wishes for this Conference of the Parties.
To the parties to the Escazú Agreement, my name is Gavin Mitchell, and I am a national of Trinidad and Tobago. I am thankful for the opportunity to be considered as one of the members of the committee to support implementation and compliance of the Escazú Agreement. I have been keeping abreast of the agreement since 2019, and my work focused significantly on access rights as defined by the agreement. When I saw the call for nominations last year, I felt very secure that I had the relevant skills and experience to make a positive contribution to the committee. I believe that the parties would find me quite capable in fulfilling the work of the committee, as I have over 10 years' work experience in environmental regulation. Most notably, my primary duties included the implementation of multilateral environmental agreements to the drafting of legislation, giving legal advice on the processing of environmental permits with an emphasis on public participation during the environmental impact assessment process, advising on the disclosure of environmental information through Freedom of Information applications, and I have appeared frequently before the local environmental court regarding mediation and litigation of environmental matters. I assure the parties that I can carry out the duties of the committee in a manner that is consultative and transparent, non-judicial, non-adversarial, and non-punitive. I wish to thank you for having me, and I hope you have a great conference.
I am Andrés Napoli from Argentina. I am a lawyer specializing in environmental law and currently the executive director of the Environment and Natural Resources Foundation, a non-government organization with more than 30 years of experience in Argentina. I have also worked in several private sector law firms and in the public sector, advising the National Congress and several local governments on environmental issues. Much of my professional career has been linked to rights of access because in the foundation we carry out environmental protection tasks using the tools such as information, promotion of citizen participation in public hearings, and environmental litigation, which we not only file cases, but also provide legal clinic working with the University of Buenos Aires. That is why we joined the Escazú process very quickly indeed, right after Rio+20, and via the meetings of the focal points. And then, in my case, I was elected as representative of the public, a task that ended in 2022. That was a very interesting journey indeed, where I've acquired vast experience. And I believe the ratification process in Argentina, in which we worked together with youth organizations, I mean, it has been a really challenging process, but I believe what is soon coming in Escazú will be much more challenging, indeed more complex, to achieve the full implementation of the agreement. And this motivated me to apply as a member of the Compliance Committee, understanding that my experience, my journey, and my expertise will help, at least initially, during the committee, to lay the foundations for its effective and integral and integrated operation. Of course, challenges are huge because we need more countries being part of the agreement. We need to find the implementation process beginning as early as possible so that these processes achieve transformations, and so that the credibility that Escazú awakens in people is actual, real, providing effective responses and not a source of conflict. That is why these are some of the challenges ahead, without leaving aside the most urgent one, which is to achieve mechanisms for the protection of defenders. This is a must today, to have tools, protection tools from the agreement. The Escazú agreement is a great hope for the region, not just from an environmental point of view, but also to strengthen democracy. In the case of Argentina, we're celebrating 40 years of uninterrupted democracy, and Escazú seems to be the right element to consolidate it. That is what has motivated me to seek membership and offer my expertise in this regard. Finally, regardless rather of any result, I am grateful for having been a member of this roster.
I'm an environmental lawyer from Jamaica with a law degree from the University of the West Indies and a master's in environmental law from the University of Aberdeen in Scotland. It's a great honor to be considered for appointment as a member of the Implementation and Compliance Committee of the Escazú Agreement. For me, if I was to be appointed by the parties, it would be the culmination of a journey that began with the Rio Plus 20 process in June of 2012 in Brazil, where I worked with civil society groups from Latin America and the Caribbean, hand in hand with the governments, to push for the adoption of the Declaration on the application of Principle 10 of the Rio Declaration, which commenced the process that led to the Escazú Agreement. I was motivated at that time to work for the adoption of this human rights and environmental agreement that was years away in the making, and I continue to be motivated to work on this agreement's implementation and to support compliance. I do this because I have seen the power of rights to information, public participation, and access to justice in my career working with the government of Jamaica for over 7 years and in civil society organizations in Jamaica and then internationally at the World Resources Institute. I have seen how they can ensure the public, including vulnerable groups, can participate fairly in decision-making about the environment and climate change, and how they can be used to build trust between government and the public in how decisions are being made. I have seen how they can be used to ensure fairness and considerations of equity on projects, policies, and planning, and I have seen how they've been used to reduce conflict and resolve issues that communities have who have differing and opposing views on environmental decision-making and what sustainable development means for them. I believe in the importance of procedural and substantive environmental rights to ensure democratic decision-making. I have seen how these rights have been used to advocate for a clean and healthy environment in decisions in my country in Jamaica and across the Caribbean about protected areas, pollution, beach access. I've also seen governments improve their own permitting and policy processes by taking into account public feedback from the implementation of these rights. If I was chosen, I would like to bring my experience and knowledge of this agreement to this position, my understanding of how to ensure all environmental human rights defenders have an enabling civic space for their advocacy, and the importance of the work to increase the public's awareness of how they use these rights. This position is non-judicial, non-adversarial, and to promote implementation and compliance. I'd be excited to support both the governments and the publics in giving advice on how to improve outcomes for communities with strong support to ensure compliance with the provisions of this landmark agreement. Thank you so much for this opportunity, and I wish you all the best for COP2 in the beautiful country of Argentina.
Hello, I'm Felix Wing Solis, a lawyer with a degree by the University of Panama and a master on legal studies by the American University. As an expert on international law, human rights, and legal law, and environmental law, I have the necessary training to form part of the committee to support the implementation and compliance as a subsidiary body to the Conference of the Parties to the Escazú Agreement, as well as I have vast experience to build upon the capabilities for the implementation of strategies for the promotion and defense of rights of access nationally and regionally. My 30 years of work experience include more than a decade in NGOs, a decade on the UN family and intergovernment agencies, and 5 years in the public sector at a national level. All along, I've defended the environment. I've taught at the university. I've been an environmental consultant, judicial operator, independent experts at rights of access, and senior public official. In this role, I've represented my country with a committee to negotiate Escazú and presided over the second meeting and working hand in hand with ECLAC and the different chairs, partnering with the delegates from the Central American Integration System and small developing island states in the Caribbean, promoting ambitious standards in the working document all along this process and participating as panelists in alternate events regarding these negotiations at the Second UN Environmental Assembly. I believe that the possibility of being elected as a member of the Committee to Support Implementation and Compliance is a big opportunity of keeping on contributing to the rights of access. Though I am aware that there are lots of commitments undertaken by the member states parties when the agreement becomes effective and the challenges of the post-COVID-19 recovery regarding global, regional, national, local rights of access, I am more than willing to go hand in hand with the states parties and cooperate with them, with the members of the public, with their representatives in the stage of initial implementation in these difficult times, with the independence and integrity as are necessary. Thus, I thank you for the opportunity of having been taken into consideration to fill this position, which is indeed transcendental. Good morning. This is Guillermo Acuña. This is again the first candidate. I think there's been a mistake with the broadcast. This was a loop. So, in the first place, we want to thank candidates from the bottom of our hearts, not just for having shown an interest. Let's give them a hand. Absolutely, absolutely. All of those that have filed their interest, especially this roster of 10 candidates that we had the opportunity of getting acquainted with, of learning about their proposals, and that will all be helpful to make a call. I wanted to remind you that yesterday, at the heads of delegations task force, the Secretariat gave you a sheet, a form with the 10 candidates listed in it, and we got the response from 7 delegations, their preference or who were their favorites. But we would like the rest of the delegations to hand it in today, because at the end of today, we want to hold a heads of delegation meeting. That would be 5:30, so we complete these proceedings timely to see, as we said today, if we reach consensus. And otherwise, tomorrow we need to go ahead with the voting. So I feel I want to deliver this to the Secretariat during today. If you haven't done so, please, we'd like you to hand over this information. There's a break now, so we'd have to resume in 15 minutes because we should have broken up before. It was a coffee break outside in the room next door, and at 11:50, I look forward to having you all seated again in the room so we can resume. Thank you.
Sí, pero no importa. ¿Dónde se usa la sala de voz?
Ahí puede bajar el transfer, no nos sirve porque se escucha el audio original y se escucha el audio de la traductora a la vez. ¿Ves? Porque están hablando y se escucha abajo como sí, pero para la traducción. ¿Pudiste escribir el video? Sí, ya está. No. ¿Te digo qué video que viene? Sí, solo el audio de transmisión. ¿Querés que...? Una ratita. Estoy capturando la independencia de Nueva y donde un poco. Internet por acá. ¿Bien? Estamos perfectos. el punto más participativo. Desapareció mi café. No sabes si...
Pensé que estaba contra amigos. Estaba en la plaza acá y desapareció. Digo, izquierda, que pensé que estábamos entre amigos, me desapareció la casa. No, tomando algo de la masa, el poquito de taquita,
A las 8 entramos a la semana. Escúchame, están de la mañana. Eso es ¿nos vamos a escuchar? Bueno. ¿Qué la conectaste? ¿A esta? La agarras sin ver. Pero ¿esta? ¿Es esta cosa? Porque no la lees. Porque no lo lees. Hacer el HDMI. Creo que 15 minutos. ¿A dónde la estaba poniendo? Acá. Ah, esta la verdad, entonces. A ver. Pero por a mí por eso, porque que reiniciar. Volver. ¿A dónde para de y luego vas a recibir ahí. ¿Te da cuando tenemos zapatos? No. ¿No? ¿Y cómo conectamos el transformador? Sí, un solo largo. Pero si pongo la larga conectado con la tele, tengo que conectar el transformador. Porque sabes que me también me queda acá. Entonces, hay todo con una sola. Pero primero pongamos esta tele sola. Después mañana pongamos la otra. ¿Sí? ¿Nosotros la zapa no? Bueno, nada. ¿Esta no se pudo salir? Sí, a mí me sí, vale. No, me la... Vamos a conectar y desconectar todo, vamos a cerrarlo el No, no, no sé. Sí, claro. ¿No tienes para ver? Ah, sí. Offline.
Igual si solo va a hacer programa el
Ok, no, pero ya, lo que pasa es que se me había apagado mi cámara. Estamos bien, ¿no?
Yo acá me estoy pasando el PPT. Yo ahora te paso el todo armado.
O sea, si tengo el papel limpio, lo voy a más.
Sí. ¿Listo?
¿Muy vale? ¿Qué onda, Ina? ¿Te viene bien?
¿Está bien, Pablo?
Hola. ¿Ay? ¿Me vieron? Claro. Sí, obvio, el hambre que tiene todo el hambre que tiene todo el mundo. ¿Mi amor, Fizz? A mí me llamaste, Alexander. ¿Quieres que te cuente o quieres que te cuente? Ah, pero ¿cómo está todo? Por ejemplo. ¿Y que las pedí? Ah, claro.
¿Estamos para volver?
Sí, ya estamos para volver. Claro, abajo, ¿viste ya te sale? Mucho sube. Y el hall para abajo. Ahora, en un rato, hay una charla, que me parece que es importante. ¿No quieres enseñar? Ahora no. Sí, ahora a las 12:30 hay una que empieza abajo. Entonces lo que hacemos es acá por acá. Acá en el hotel. No te están diciendo. Es esta. Ok, vale. ¿Qué es eso? Sí, dale. Y está ahí. No, yo le mandé mensaje, pero le mandé. No. Sí, se lo hice. Claro, acá no quiero contratar el bar, ¿me entiendes? Quiero que ustedes funcionen acá, invitados, ¿no? ¿Qué me digo? Vamos a inaugurar, chicos. Vamos a inaugurar. Capturate el programa. Va a ir a meterle toda la cosa allá. Capturate el programa.
Bueno, vamos a ir comenzando. Si se quieren ir acomodando.
Let's resume the meeting. Please take your seats.
No,
¿Ya? Ah, porque ahora solamente están buscando el...
No, o sea, ahora solo tenemos eso. Que alguien llegue a una pantalla para que la gente pueda ver. ¿Sí? Y además,
¿Lo ponemos?
sí.
ya lo tenía, ¿no?
Sí, pero se lo cambió a
Ok, no pasa nada.
Bueno.
Vamos a...
Now, we resume the meeting. I hope you've enjoyed the coffee. Maybe you've had some mate with an Argentine co-worker. So we are beginning our first special session of this extraordinary conference, and we're going to deal with comparative experiences of implementation and compliance support bodies. As you know, Article 18 of the agreement establishes that the Committee to Support Implementation and Compliance is a subsidiary body to the Conference of the Parties, whose objective is to promote the application and support the parties in implementing the agreement. The second paragraph of Article 18 features some issues on the committee, for instance, that it shall be of a consultative and transparent nature, non-adversarial, non-judicial, and non-punitive, and shall review compliance of the provisions of the agreement and formulate recommendations in accordance with the rules of procedure to make questions or comments in order to make this session even more fruitful. So without further ado, Jonas, you have the floor. Thank you.
Thank you very much, Madam Chair. Thank you for inviting me. So dear participants, dear community of the Escazú Agreement, I'm honored to be invited to this conference of the parties when the Committee to Support the Implementation and Compliance of the Escazú Agreement is to be elected. As a bit of background, I joined the Aarhus Convention Compliance Committee in 2005, and in 2011 I became the chair of the committee, and I stayed as the chair for 10 years until 2021. Not only are the Escazú Agreement and the Aarhus Convention similar in many respects and built on the same spirit of promoting participatory rights and access rights, the protection of environmental defenders, and the promotion of the rule of law in environmental matters. The committees of the two treaties to review compliance and implementation also have many elements in common. I have followed the development of the Escazú Agreement from the very beginning, and I attended one of the sessions in Santiago de Chile during the negotiations. I was also asked to assist with comments and views on the drafting on what was to become COP Decision 1/3 on the rules relating to the structure and functions of the Committee to Support Implementation and Compliance, which I did. Based on my experience in the Aarhus Convention, which I also followed from the start in the 1990s, and I was also involved in drafting what was called MOP Decision 1/7 on the Compliance Committee, I think it's very good that the Escazú community, if I may use that term, has not rushed with the details on the new committee. While it was established by the agreement itself, the rules on its structure and functions were adopted a bit later, and now you are electing the committee. The situation was the same with the Aarhus Convention, and I think it was important to allow some time to establish this new kind of committee, and also to let it develop its working methods. This created mutual trust among the parties and also among active non-governmental organizations. At the outset, when the rules and procedures for the Aarhus Convention Compliance Committee were negotiated, some states were concerned about an independent committee which would allow communications not only from parties but also from the public. As time went on, also the states that had not been overly enthusiastic in the beginning changed their views. And at the first meeting of the parties, the Aarhus Convention parties were comfortable, and some were even enthusiastic, with the idea of a compliance mechanism with the mandate of reviewing compliance on the basis of communications from the public. Thus, the committee was established. And I should congratulate the parties to the Escazú Agreement in particular for following this idea of not limiting the compliance mechanisms to acts by the parties. The trigger of the committee's review by members of the public is fundamental to the practice, to its relevance, and to the effectiveness of the treaty itself. As of today, the Compliance Committee of the Aarhus Convention has about 200 registered cases, decided and pending. Of these cases, 197 are communications from the public, and 3 are submissions by the parties. Of these 3 submissions, 2 are submissions from parties against another party, and 1 is a submission from a party concerning its own activities. In addition to this, the committee has registered 4 requests for advice outside the scope of specific cases, but it has also given advice as part of follow-up of cases of non-compliance. So these approximately 200 cases, 197, are based on communications from the public. And in other words, without these communications from the public, the committee would have had hardly anything to do in these more than 20 years. I'm not saying that the 3 submissions were not important, they were, but they were highly important for the committee. And of course, more importantly, it was important for the performance of the parties. It would have been far worse, and the issue of participatory rights and access right in environmental matters would have been much less debated in the public if it was not for the activities of the Compliance Committee. During my time as the chair, while strictly complying with the rules agreed by the meeting of the parties, the committee made significant developments in its practices and working methods. You can find a comprehensive explanation of the functions and working methods of the committee in the document titled Guide to the Aarhus Convention Compliance Committee, agreed in 2019 and available on the website of the committee. I think the parties to the Aarhus Convention, and importantly, of course, to the Escazú Agreement, have nothing to fear by a compliance and implementation committee of this sort. The committees are not courts or bodies to settle disputes. They are bodies intended to promote compliance and implementation of the treaties in a constructive yet serious manner. I have also heard worries that the Escazú Agreement could have a negative impact on investment, and I can assure you that this is not the case. There is no reason to worry about investment in this regard. We see no indication whatsoever in Europe that the Aarhus Convention or the compliance mechanism have had any negative impact on investment. So I want to share this with you. The Aarhus Convention and the Escazú Agreement are about promoting the rule of law in environmental matters. And business usually appreciates clear and predictable rules to follow. In sharing the lessons learned by the Aarhus Convention, I would highlight 5 key elements for the structure and the functioning. The first is about law. As I said, the Compliance Committee is not a court. It is an independent and impartial body to promote compliance by reviewing the performance of the parties with a legally binding treaty. This is an exercise of international law, and therefore it is important that the committee acts in a responsible manner in all its activities. When interpreting the treaty as part of its review, it must do so, and I quote, in good faith in accordance with the ordinary meeting to be given to the terms of the treaty in their context and in light of its object and purpose, as the Vienna Convention on the Law of Treaties says. The committees are there to promote performance in compliance with the international obligations of the parties, to ensure participatory rights and access rights, and to protect environmental defenders. The second key element is integrity. To live up to its mandate, one of the most important messages to the community of the Escazú Agreement and to the new committee under the Escazú Agreement is that it must act with integrity and it must be independent and impartial. The Aarhus Convention Compliance Committee has always acted independently and with integrity, and it has not been biased vis-à-vis state parties or civil society organizations or the public. And to act with integrity, the committee must make sure that committee members do not have any conflict of interest in the case. During my time as chair, we had quite a few cases where a committee member had previously done some work either for a government or for a non-governmental organization who was a party to the case before the committee. When that happened, that committee member had to step down from that case and did not participate in any of the closed sessions and deliberations of the case. The important issue here is not what the committee member thinks herself or himself, but how this is perceived by the parties and by the outside world. Nobody must think that a committee member has a conflict of interest in a case. In some cases, when it was not clear whether the committee member could be seen as having a conflict of interest in the case, maybe because of some of the work done many years ago, I asked the parties whether they thought that the committee member had a conflict of interest. And if they said so, well, then that committee member would have to step out. And if they agreed that it's fine, then we could proceed. Moving on, my third key element in the practice and working methods of the committee is due process. By that I mean essentially procedural fairness in the treatment of the parties and the review of the compliance. While again, the committee is not a court. Here I think it's useful to act in the same manner in treating of parties. Yet there are many important differences, but one is that as part of the review, the Compliance and Implementation Committee is not limited only to the views and information provided by the parties. At least that was the case in the Århus Convention. It was very useful to take note of facts provided and information provided by observers. In practice, due process meant to treat those involved equally, act in a transparent and a foreseeable way, so that the governments and the communicants are duly heard, and that their arguments and information are duly taken into account. Another point here, which was one of the most difficult issues for me as the chair, was to try to complete cases swiftly, without compromising on due process. The committee members are not paid and do the work for the committee on top of other tasks. As to myself, though, I think I spent about 25–30% of my working time for many years for the committee itself, on certain occasions much more than that. The Secretariat was also always very active and competent, but yet it had limited capacity in terms of staff. So we were trying to do the case as swiftly as we could, but due process took its time. And I think when the committee receives many cases, it creates a backlog, and the committee must find ways to deal with that. And I assume that it would be an issue for the Escazú Agreement Committee as well, to find ways not to create too big backlogs. I move on to the fourth key element, which is constructive dialogue. The review processes in themselves involve exchanges and views and arguments, and as the chair, I also thought the discussions on specific cases were part of an ongoing dialogue on what to expect from the parties to the convention. This is the same with follow-up cases when parties have been found non-compliant and are to get in compliance with the treaty. In addition, I see that this is also part of the working method of the committee under the Escazú Agreement. The Compliance Committee organized specific open dialogue sessions on important matters related to the implementation and compliance. This could also refer to the working method of the committee itself, to have an agreed procedure, again, to be transparent and act with due process. So as an example, for the first 10 years or so, the Compliance Committee held open hearings in all cases that were found admissible. It was very useful. It has been important for the parties to be present in person. Later on, however, when the caseload became too large, it was impossible to have hearings in all cases. Therefore, I proposed to the committee, and we discussed this at length in open sessions with parties and members of the public, that we should not have hearings in all cases if the hearing was not a necessary element. This was finally agreed. It took quite a while. Yet it is fundamental to hear the views of the parties in each case, what they think about the hearing. Usually the committee would accept if one of the parties, the party concerned or the communicant, insisted on a hearing, but nevertheless it is the committee that finally decides on whether to do that. And we had cases when we did not proceed with the hearing. The open dialogue sessions brings me to my last point and my last key element, which is trust. The Århus Convention, just like the Escazú Agreement, are intended to achieve the overall objective of ensuring access to information, public participation and access to justice in environmental matters, and of protecting environmental defenders, and thus to contribute to the protection of the right of every person, of present and future generations, to live in a healthy environment. This is what everyone in the Århus and Escazú communities should strive for. To contribute to that, it is also fundamental that the treaty bodies, like the Compliance Committee, actively work to promote trust in their activities and trust in the review procedures. And I have given a few examples of how that can be promoted. The key matters that I have just highlighted helped to do so, acting in accordance with international law, ensuring integrity ensuring due process, engaging in dialogues with the parties, and promote trust are essential elements to ensure participatory and access rights to the public. Essential to promote compliance by the parties and thus to contribute to the protection of the right, and I repeat, of every person and of present and future generations to live in a healthy environment and to sustainable development. And I will be happy to respond to any questions that you may have later on. Thank you very much.
Thank you very much. Y ahora vamos a continuar con...
Now we're going to continue with Paulina Riquelme, Chair of the Committee for the Support of Implementation and Compliance of the Minamata Convention on Mercury. Paulina, thank you, Chair. Good morning, everyone. I'd like to thank Argentina for hosting this conference and the ICLAC as the Technical Secretariat of the Escazú Agreement for organizing this and inviting me to participate here. I was asked to talk about practical issues related to my work as an outgoing chair of the Committee for the Support of Implementation and Compliance of the Minamata Convention. So this convention is relatively new, and it is intended to regulate the life cycle of mercury. This Committee of Implementation and Compliance is regulated in Article 15 of the Minamata Convention. It's a subsidiary body of the Conference of the Parties, and it is intended to promote the application and the provisions of the agreement. It's composed of 15 members proposed by the parties and elected by the Conference of the Parties, taking into account the equitable geographical representation of the 5 UN regions. The members of the committee must have appropriate professional competencies for the function and have a balance of knowledge that is specialized and that is appropriate considering the convention. The members of the committee have the duty to act objectively in an unbiased way and for the best interest of the conference or the agreement. After they are elected, the members must be independent. They no longer represent their country or region, and they become experts that are devoted to the better operation of the agreement or the convention. This is a voluntary role, and it entails work and commitment. The expert must be available to perform its tasks and support the Secretariat in all issues related to compliance and promotion of the implementation of the convention by the parties. Fundamental aspects of the committee members. These are independence, impartiality, knowledge about the convention, availability and commitment, and collaborative spirit. The committee is a facilitator, and it's not punitive, and must provide special attention to the capacities and national circumstances of each one of the parties. And it is supposed to promote the application and to examine compliance with all the provisions of the convention. Therefore, the committee examines specific issues and also systemic issues related to the enforcement, application, and compliance of the Minamata Convention, and can prepare recommendations to the Conference of the Parties. The committee can also make recommendations to one party to the convention at the request of that state party or at the request of the committee if there is an agreement among the members. The committee, in accordance with its work plan and with the budget, may request additional information through the Secretariat from a party or from all the parties when there are difficulties, systemic difficulties related to the application and compliance with the agreement or the convention. It may conduct consultations with other subsidiary bodies of the convention and also of other conventions as well, and request additional information and to ask for external experts through the Secretariat if necessary. If there are individual difficulties related to the application and compliance with the convention, it can request additional information to the party in question and resort to external experts. Also, take advantage of the knowledge of the technical secretariat and request information regarding the affairs subjected to its consideration. Regarding the rules, the committee works based on its procedural rules or rules and regulations, which was agreed in the second conference of the parties, and its terms of reference that were adopted in the third conference of the parties. And compliance with the rules is very, very relevant for the correct operation of the committee. And regarding the practical issues, the Conference of the Parties of the Minamana Convention, in its first meeting, elected the first 15 members of the committee. The first members of the committee held office in the period that started at the end of the first ordinary meeting of the Conference of the Parties up to the closing of the third ordinary meeting of the Conference of the Parties in 2019. In the third ordinary meeting, the Conference of the Parties elected 10 members from the first members of the committee for a term and 5 new members for 2 terms. So the term of office is a period that starts at the end of an ordinary meeting of the Conference of the Parties and finishes at the end of the following ordinary meeting of the Conference of the Parties, and a member cannot hold office for more than 2 consecutive terms. As of today, there have been 5 sessions of this implementation and compliance committee. The first one was in May 2018 in Geneva. The second one was in 2019. And then in 2021, with the pandemic, there was a third session that was an online session. The fourth session was also online. And the fifth session was held in March this year, and it was an in-person session. This fifth session was very interesting because the committee had to consider and analyze the report prepared by the Secretariat of the Convention, of the Minamata Convention, regarding the national reports prepared by the parties for the first complete cycle of the convention that included 2017 to December 2020, which was focused on the responses to the 43 questions that are part of the national report. Regarding practical matters, according or based on the internal organization, the first thing that the committee does is organizational issues, which entails approving the program, electing the officers, and organizing the work. And this has to comply with the mandate of the committee. During the in-person committees of the committee, among the member present, a president or chair is elected, and a vice president or chair is elected, and in this case, that person would be the rapporteur, taking into account the equitable geographical representation of the 5 regions of the United Nations. The president and vice president offices are subject to rotation among the members. The president is the leader of the committee and has the responsibility of leading those meetings in an effective way based on certain principles, such as impartiality, respect, patience, and being able to listen to the opinions of all members present in the venue, active listening and being able to convey different points of view, and promoting a respectful dialogue. The president or the chair declares the meeting open and closed, presides over the sessions, controls the application of the rules that apply to the committee, and subjects affairs to voting, and also announces the decisions. The president decides over questions of order subject to the rules and regulations, and will have full authority to lead the deliberations and to keep order at them. The chair proposes to the committee the closure of speaker lists and the limitations to the time allocated to speakers and the number of speakers as well, and the adjournment of the session if needed. The chair is subject to the authority of the committee. There is a minimum quorum to hold a session. A president cannot open a session and will not allow deliberations unless there is 1/3 of the members present. And 2/3 of the members shall be present to be able to adopt any decision. Each member of the committee has 1 vote. The committee must do everything in its power to be able to approve recommendations by consensus. After all the efforts have been made to be able to reach a consensus, but unsuccessfully, recommendations will be approved as a matter of last resort by the affirmative vote of 3/4 of the members that are present and voting, with a quorum of 2/3 of the members. Finally, the committee must prepare a report in each one of the ordinary meetings of the Conference of the Parties in the Minamata Convention about their task and their functions. According to the Convention, the terms of reference, and the procedural rules. The report must include recommendations, or could include recommendations, for its consideration and adoption by the Conference of the Parties. It is a very nice task, and all the future members that are elected for the committee for the compliance and the enforcement and compliance of the Escazú Agreement, I would like to invite you to have always leadership, constructive spirit, and enthusiasm. Thank you.
Thank you, Paulina. We'll move on to Julieta Rossi, member of the Committee of Cultural, Social, Economic Rights of the United Nations. You have the floor. Thank you. Good morning, everybody. I thank the invitation to participate in this event and ICLAC as a technical secretariat to the agreement, and to celebrate the setting into motion of the committee to support the implementation and compliance of the agreement through the election of the first members. It's key for complying with the agreement and applying it, and also the entry into force. It's vital for our region in terms of a climate emergency and for severe risks for human rights and environmental defenders, many of whom are women. As a member of the Committee of Cultural, Social and Economic Rights Committee, it's an implementation committee. I act I speak in a personal capacity. I'm going to touch upon the topics that propose 3 of them. One has to do with methodologies and procedures to tackle or address communications by the public. Secondly, to develop general observation and declarations. And third, follow-up mechanisms for recommendations and observations made by the committee. By way of introductions, the treaty committees of the United Nations and the Escazú Committee have some similarities, but also some differences. This has to be borne in mind, and my suggestion would be to consider these differences and similarities. Committees, the United Nations committees in general, and my committee specifically, has some roles, for instance, to conduct assessments through the regular reporting system in complying with the pact or the treaty through submission of regular reports and constructive dialogues. After them, we create recommendations and observations. On the other hand, we have to create individual communications made by the people who have been affected or the victims of violations of the rights that are protected in the treaty, with the chance of having a specific decision on that specific situation. Communications can be submitted by states as well, and committees in general, or some of them, can lead systematic investigations regarding serious violations to the protected rights in that treaty. And considering the scope of work of my committee, I would make some recommendations that can be considered by the committee to support the implementation and compliance of the Escazú agreement. Now, the handling of cases. And knowing that one of the key criterions for implementation is this meaningful participation of the public, a key point is to have how accessible the system is to the victims, ensuring that the economic situation and access to advisory services, how to state or file their cases. Communication should not hinder their accessing the systems. We can see that victims have hard times in getting into the system and making their communications or filing their complaints. The rules of procedures establish that the committee should consider the importance of conducting hearings with victims when they are admissible or when the substance is considered. I mean, coming close to the victims is key for our effective work and for a proper compliance of Escazú's provisions. It seems to me that it's also important to have case hearings held in different countries. The committee can have different types of hearings in different countries at the United Nations. This has some sort of financial restrictions, but this is an issue that has been continuously discussed. The rules of procedures for communications of my committee provide for a friendship or a friendly settlement of disputes. Only when there's a joint settlement can we come to more positive outcomes. Instead of waiting for the end part, the victims or even the states can settle the dispute by themselves, including interim measures to avoid serious damages or to establish them on an autonomous basis, for instance, these protection measures as encompassed in the human rights agreements. In the desk committee, this has been very important because the first cases, or many of the current cases, have to do with filing complaints due to forced when protective measures are implemented, this provides for the eviction of vulnerable people who have no other place to live. Protection measures for those who submit communications to the committee, or they can be endangered, or they suffer risks of being to have retaliation. We have the chance of establishing measures to protect environmental defenders. These measures
Otra cuestión importante que está establecida en las reglas de procedimiento del Comité de Derechos Económicos, Sociales y Culturales es la previsión.
I'm sorry, the sound was disconnected. Now we are back again. In case this gives us the chance of having a mandatory stage in terms of deadline for state parties to comply with what the committee's recommendation. As to Escazú, this additional tool, that is the intervention of the conference of the party in case of non-compliance, with specific powers that have an additional value added, and are not foreseen in the universal system of human rights committees. Another important topic is the participation of other parties, the public, for instance, or the participation of third-party experts that can offer their specific specialized knowledge or views about the topics that is being dealt with. And lastly, I think we should establish deadlines for communications. I think it is key or critical for international legitimacy questions. This would apply to this committee. I mean, communications should be made in reasonable periods of time. They should not go beyond many years, because in some international systems, deadlines end up being a problem, and they undermine the legitimacy of the protection system. The second topic is about general observations or substantive recommendations. My committee at the United Nations had the chance to develop interpretation of the rules of the provisions in different treaties. That's important. I think the Escazú Committee, given its specific rules, has an important role to play in interpreting the rules. It should do it as well, bearing in mind the development of other systems from the UN committees, but also the inter-American human rights systems. For instance, the DESC committee is developing a general observation on sustainable development. The Committee on the Rights of Children, a recommendation of climate change and environment, and the Inter-American Committee on Human Rights accepted a consultative opinion from Chile and Colombia to develop this consultative opinion. There are overlays that I think that Escazú Committee, when assuming this role in developing rules, should bear in mind, considering the integration of international law, human rights, and the environment. The substantive declarations are shorter or more limited, but they can tackle specific issues. They are shorter, and they tend to develop standards, but they are important to set agenda items and to start developing some topics from a regulatory point of view. The DESC committee has 2 declarations on environment and climate change in 2019 and 2020. Also another declaration of human rights defendants related to environmental affairs. And during the pandemics, it developed 2 declarations about the pandemics and violations to cultural, social, and economic rights, and the equal access to vaccination resources. The last point in my presentation has to do with following up on observations and recommendations. I think that we should focus on developing recommendations and regulatory interpretations. The committee should also focus on the impact and effective transformations, effective and positive change that the committee can create. And this is relevant to give legitimacy to the system. Sometimes the emphasis is too much placed in developing standards, resolutions, recommendations, but there's not as much emphasis placed on effective implementation. So I think the committee, aside from developing recommendations, should place special attention on implementing those recommendations to allocate funding, resources and technical support for this stage. In the universal system, some specific mechanisms have been developed. Over the last years, more focus has been placed at the implementation stage. So almost all committees have developed mechanisms to follow up on recommendations through the periodic report mechanism. Some of them are prioritized, and in a short period of time, 1.5 years or 2 years, states are requested information about the processes in complying those recommendations with certain categories. Those are some specifics, but these categories enable us to assess whether the states are making progress or not. Some committees, during this follow-up procedure of recommendations, have developed field visits. This is an important tool to assess the progress made and to get engaged and involved with state authorities and with victims as well. To conclude, the universal system is promoting the fact that states should have report submission and follow-up on recommendations mechanisms. There should be a focal point in the states to follow up and to report the international bodies and to hold interactive dialogue with committees in general. And finally, the need to establish some indicators to monitor the compliance and implementation of Escazú Agreement. We have the experience of the working group of the San Salvador Protocol. This is an optional protocol to the Inter-American Human Rights Convention, and this committee, this working group rather, has created specific indicators to follow up on the state's commitments. So the Escazú committee might bear them in mind. And I mean developing specific indicators or metrics to strengthen how states are behaving in complying with the Escazú Agreement. That's all. Thank you.
Thank you, Julieta. Thank you so much. And now, the Secretariat brought a 4-minute-long video where we can listen to Cristina Boyd and Hassan Hobart, co-chairs of the Compliance Committee of the Paris Agreement.
Distinguished President, esteemed presiding officers and delegates, ladies and gentlemen, as co-chairs of the Paris Agreement Implementation and Compliance Committee, more commonly known as the PIKE, Hasib and I are honored to address you today. In particular, it is our pleasure to be here on the occasion of the election of the inaugural members of the committee to support implementation and compliance. We certainly understand the importance of the committee's work and stand ready to assist however possible. As many of you may be aware, the mandate of the PIKE, as outlined in Article 15 of the Paris Agreement, is to facilitate the implementation of and promote compliance with the agreement's provisions through a transparent, non-adversarial and non-punitive approach. We have made significant strides in developing our operational framework, with our rules of procedure having been adopted at COP26 in Glasgow and COP27 in Sharm el-Sheikh. These rules form a comprehensive package ensuring the committee's proper functioning, fairness and transparency in our engagement with parties. The PIKE now stands ready to offer its expertise and guidance. We look forward to working collaboratively with all parties to the Paris Agreement to advance our shared goals and overcome the challenges we face together in our pursuit of a more sustainable and resilient future for all. To this end, understanding the 4 modes of initiation under which the PIKE engages with parties is crucial. These modes provide a structured framework for our work, enabling tailored approaches to each unique circumstance. The first mode of initiation involves a party initiating engagement on any provision of the Paris Agreement. Second, the committee may initiate engagement where a specified mandatory requirement of the agreement is not met. Third, with the consent of the party, the committee may engage in cases of significant and persistent inconsistencies based on the recommendations in the Technical Expert Review Report. Lastly, the 4th mode involves considering systemic issues by the committee, either independently or upon request of the Conference of the Parties, serving as the meeting of the parties to the Paris Agreement.
Our commitment to facilitating implementation and promoting compliance is grounded in the understanding that the success of the Paris Agreement depends on a collaborative and cooperative and supportive approach. This includes the fact that the committee has a non-exhaustive list of measures at its disposal, from engaging in dialogue with the parties to offering assistance or guidance to address the identified challenges, to make the recommendation to the developing countries or the developed countries on the action plan. As we transition from establishing our foundation to fully operationalizing our mandate, we must focus on reinforcing the critical message that we are ready to engage with the parties concerned and for their implementation and promoting compliance with the Paris Agreement. Our dual mandate is both broad and complex, but we are well equipped to meet these challenges, largely due to the comprehensive set of rules that have been established and functional. In conclusion, ladies and gentlemen, we would like to wish you all the best for your work at this session, and in particular for the launch of the work of the committee to support implementation and compliance. While we certainly understand that setting up a committee of this nature isn't always without its challenges, however, we also know that this work is of the utmost importance to the achieving the objectives of Escazú Agreement, and we are more than confident that your efforts will be a success. I thank you all.
Thank you. And I would like to thank those of you for joining me here at the table, for sharing your knowledge and your experience. We're going to have 15 to 20 minutes to ask questions, make remarks, so that the delegations can participate as well, and also the people that are present in the audience. You can ask questions to any of the experts that we have here at the table, or make any comments before we close this session. I have my first candidate here and then the second one here. So first Carlos and then Antigua and Barbuda. Thank you, President. To break the ice, the Escazú agreement is almost the last agreement right after Minamata, and we're still building this, as you very well heard. And Jonas and most of you refer to the support by the Secretariat to the committees. And so please, if you have a couple minutes, can you enlarge on that? Because the committee, of course, is very important, and it's very important for the committee to have the means to be effective. And so we would like to have some clarification about the expectation regarding the practices that we have to implement in the future.
Thank you. Ruth Spencer from Antigua and Barbuda. The gentleman from the Aarhus Convention said, in all your experiences, no investments were jeopardized. And I know in your country you enforce laws and regulations. But in countries where laws are not enforced, development seems to be the major area where the threats to human health and the environment takes place. In my country, because sometimes the principles of Escazú, access to information, consultations do not take place, and some of the development projects are seen like state secrets. You only see them happening on the ground. You have no access to information on these projects. And so when you see things happening, then the communities, start asking questions. They get on the radio. What is this? What's happening in our communities? We weren't informed. We didn't have a say on these developments. So in that way, our advocacy tends to request a halt on these investments. And we have had to be doing quite a bit of bold advocacy on the media to put a halt to developments that are in, say, protected areas, key sites where, as a small island country, it can weaken our resilience, reduce our natural protective system. So in this way, I would say we have had to push to put a halt on some development and investors. Last night, the Argentine Prime Minister says, Escazú agreement and development are not on the same track. Because with Escazú, you are asking for a new form of system where you alone don't make the decision anymore as a politician, as a government. You are including now the ideas, the observations, the inputs of other stakeholders. So in that way, the development is threatened. The development has to be put on hold until we, the people, have access to information and those consultations processes. Thank you.
Thank you, Ruth, from Antigua Barbuda.
So now we're going to answer the two questions, or should we take a third one? Okay, we can take the third question from Colombia, and then we'll answer those three, and then we'll have another round of 3 more questions. Thank you, Chair. 2 issues that I think are important. Actually, one has to do with the access to the support committee, and the other one has to do with the compliance with the recommendations. So we know that much of the social and environmental conflicts in our countries take place in rural areas that are remote, that have difficulties in accessing and in communication, and many communities are threatened and they depend on the territory. So the way to facilitate access to the committee is something that is of concern to us. Our countries in our countries, communication, internet, and technology in rural areas is, a complex issue. And so many of these communities, for them to move to rural areas or to get displaced to rural areas is a problem too. So, for example, how would they approach the committee to share concerns? That is of concern to us. So, in light of your experience, do you have any progress in that area? If we're talking about OROS, we're talking about Europe, of course, which has different situations. But then regarding compliance, and I'm going to make reference to a specific case, the desk committee. We had consultations in Colombia where people voted directly on what they wanted on the territory. The government was opposed to this. But in any case, we were present in the desk committee as Colombian citizens, and there was a recommendation of the desk committee to the Colombian government that was never complied with. So what do we do? How do we materialize rights? How do we comply with? How do we enforce when these principles, of course, all are included in all the treaties, but they respect the sovereignty and autonomy of the countries, right? So we're concerned with compliance and enforcement because, of course, we would like to know about the experience of how we can move forward to materialize rights. Thank you. Thank you. So we're going to answer the first 3 questions, and then we'll have a second round of 3 questions. So who would like to start?
Pertinent questions. So I take the 3 questions in a row. So the first one was by the Secretariat, Carlos, who asked about the role of the Secretariat. And the Secretariat played a fundamental role for the committee, and I was working almost on a daily basis with the Secretariat to the Compliance Committee. Of course, the Secretariat helped in serving with logistics and organizing the meetings, practicalities. When we are communicating with parties, the letters that are sent were drafted by the Secretariat and then decided by the committee. These are very obvious things. But we also had help from the Secretariat in getting information and in also drafting findings. We had a system in the Compliance Committee where each case, which had been preliminary admissible, had a curator, which is like a rapporteur. And for the curator, the Secretariat was also helping to prepare text, the frames, and then the rapporteur was presenting the draft for the committee. And these things were done in closed session. And I again should point out, I think it's very important that the committee has certain sessions in that way. But here the Secretariat was very important. And again, we had a number of cases pending at the same time. So the Secretariat was also helping with providing legal information if we needed drafting. I mean, the committee members, like myself, come from countries where English is not our native tongue. And it's very helpful also to have support from a Secretariat when the texts are edited. So these things take time. I was on a few cases on missions to parties at the invitation of governments. And also in these cases, the Secretariat did not assist me on the trips, but it helped in preparing for these meetings. So there were quite a number of cases and issues. When we organized dialogue meetings, of course, communicating with all the parties and civil society organizations, when we were drafting this document that was called the Guide to the Compliance Committee, it took actually a few years to set up that because, again, we wanted to make sure that this practice was also agreed by everyone who was involved, not only a committee document. Here, too, the Secretariat was very helpful in checking the reactions from the parties from civil society organizations and preparing these documents for the committee who could then decide how to deal and what to agree based on these comments. So there were a lot of issues. And again, I must say, the backlog that was created was not because of poor quality of the Secretariat. I've always been very impressed, very dedicated, very committed. You would not expect anyone to work like they did in Geneva. I think I had phone calls when we were in the run-up for meetings, committee meetings or meetings of the parties at midnights, at weekends, to go through things with the Secretariat. It's more than you could expect, but we were very much dependent on the Secretariat. So sorry to take up some time. Then the questions from Antigua and Barbuda. I didn't say that the participatory rights or the access just does not influence investors in our country. They do, and it is important. I mean, these rules are set up to create for participatory rights the rule of law, because we think that is important. Most serious business agree to that, and they should agree to that. The point that I say is that, and we had also many cases dealing with big investments, nuclear power plants, wind power, dams, industrial activities, city planning, where lots of money were involved in investors. So it's not that they were not affected, but I think they should be on board. And just like serious businesses, even increasingly now linking human rights to businesses, we see they should accept this. But my point was that we have not seen in any case that this had had an impact generally on the level of investments. I have never heard of any case in any country of the almost 50 countries who are parties to the Aarhus Convention. We have big differences in economic and political and social situations, but I have never heard any party say that this treaty or the compliance committee is a problem because it prevents investments. I mean, and I have difficulty in seeing that. I mean, I'm not aware of all the details in your countries, but I think it's important to stress that the corporate sector, the private sector, should abide to this too and follow this. And I only hope that these new rules will help also to make it transparent, that you should be able to access documents that you have in the public authorities especially, and if not, to have that reviewed by an effective compliance committee. Then on Colombia's question about, I'm aware of the situation. We have problems also with members of the public being harassed, persecuted, or even penalized in some countries for their active engagement with this. But I do know, I've been working a bit with Colombia, and I know the situation is very special there. And my impression when I visited Colombia, actually 3 times last year, was that this seems to be an issue that both governments and civil society take very seriously. The convention does not set out in detail how you would like to establish your decision-making procedures. It's up to each party to decide on the format as long as you meet the minimum requirement, that members of the public should be informed, that they should be able to present their views, that their views should be taken duly into account. But then, whether you have central or regional bodies, the way they are composed, is up to the party concerned, as long, again, as they fit and meet the minimum requirement. So it's very much about, again, I mentioned due process in the compliance mechanism, but it's very much to ensure due process, both in the decision-making by administrative authorities, and of course, in the judicial branch to comply with access to justice requirements. Thank you.
Thank you, Jonas. Continuamos. Gracias, Presidente.
Thank you. Regarding the first question, with the Minamata Convention, the Secretariat plays a key role in technically supporting the Committee to Support Implementation and Compliance. They were the first to review and create a report with the analysis of each of the national reports submitted by the states parties. They created a document, and the work of the Technical Secretariat supports the Committee of Implementation in a very relevant manner. And the work in conjunction with the chair, especially in March and February, was really hard work. We had early morning meetings in Chile with European counterparts to prepare for the meeting, and during the meeting they supported the committee. It's worth mentioning that the working language of the committee in Minamata is English, and we have no simultaneous translation. So it's really important for the members to speak 2 languages. Otherwise, there will be an obstacle for knowledge and participation. So financing plays another key role, because we should have minimum requirements, and we need to organize ourselves. The committee members work for free, but we need to fund traveling expenses, consultancy jobs, and so on and so forth. That's the important role of the Secretariat in supporting the committee. Regarding the second question, the laws in each country should be overseen and enforced. Enforcement plays a key role, and all types of laws, environmental laws or acts, but also laws regarding the access to information and participation. And the third question, we should consider to be clear regarding the expectations regarding the role of the committee to support implementation and compliance. Its role is to promote the implementation and compliance in a non-punitive way, at least in the Minamata Convention. I understand the Escazú Convention also provides for that language. Non-punitive, facilitated, promoting, educating the parties, but it's not within its scope to enforce the agreement. The compliance of the agreement is within the states parties' responsibility. It's not within the committee's scope to enforce. Its role is to exercise its terms of office, to work in an impartial manner, to listen to observers. And this happened to us in our March session, when we see some non-compliances. We should call upon the states parties that are lagging behind due to national reasons. There's also the financing issue here, the resources to adequately implement the committee, and also there's a capacity building issue and technology transfer, especially in a case like the Minamata Convention. I think some other conventions like the Basel Convention should have a similar case. So I think the committee should not take on responsibilities that are not within its scope. So in relation to the support of the Secretariat, in the case of the United Nations, they play a critical role in doing work, because independent experts work for free, and they attend the sessions. They are 2 or 3 based on how each committee works. So it's really important to have technical staff working on developing drafts. We work that way. The Secretariat developed draft copies for individual communications. And within the periodic reports as well, I think it's critical, it's key to have necessary funding for people, a reasonable amount of financing to support the operation of the committee. Secondly, accessibility. I placed emphasis on that topic. The committee could foresee some specific fund or a specific line of work to ensure accessibility. This should not be up to whether it happens or not according to each individual country's context, as Colombia was saying. but not only in Colombia, but in many other countries in the region. So the committee could create a specific line of action regarding accessibility, allocating some funds, of course, as decided by the states parties, but this is not alien to other international mechanisms. The Inter-American Human Rights Body provides specific funding to victims who cannot afford it. But also considering some other issues, rural areas, long distances, the risk that many people face, especially environmental defenders. We should work along one line and to devise or create specific ideas, come up with ideas to create adequate accessibility for victims. Another point is having a committee operating in each country. I think that's important for accessibility purposes, because if the committee goes down to different countries, this is a time of bringing the Escazú agreement to the political agenda so that the victims can access the committee, having hearings. I think this is a key point. I mean, again, the committee coming down to the territory, maybe not in all conflict areas because that would be impossible, but at least having sessions that can rotate among the different state parties. And finally, regarding compliance, we should address it, and it must be on the agenda to do so. In the international system of human rights, this is not on the agenda. So to start, we should place it on the agenda to create compliance mechanisms. I think that mechanisms can help in the follow-up activities. I think they are tools that facilitate matters. Ultimately, it's always the political willingness of states. Here, all the states are present. So if a state commits to an agreement or a treaty, it should be complied with. They are international obligations that are binding. So we should call upon the states, and if they commit to a treatment and it's ratified, they should comply with it, enforce it, rather. And as we know, there would still fails compliance issues, but activism plays also a key role to support these cases. The fact of having a committee, the organizations should not rest on their laurels and thinking that a committee will bring about compliance. So activism, pushing behind and pressure to states in order to stay compliant with all the strategies. I think that's an important point to bear in mind. Thank you very much. Now, we are going to continue with some other two questions. First, Chile, and then the representative of the public. Valentina, you have the floor.
Muchas gracias, Presidenta.
Thank you, Chair. This is the first time that Chile intervenes today, so I'd like to thank our sister country, Argentina, for their hospitality and those who have warmly welcomed us, because we are now part of the Escazú Agreement. And also, having listened to the experts, clearly there is a call for working with us and commitment. And so, giving your testimony, I would like to thank the 10 candidates to become members of the committee, because that means commitment as well. I had a question that was very similar to Carlos de Miguel, but I think you have already answered a bit. And my question was, what responsibilities do we have as state parties, together with compliance and good faith compliance with a treaty to which we are a party? We have to think about the commitment and the responsibility of providing cooperation so that the bodies of the treaty can operate, such as the Committee to Support Implementation and Compliance. So my question has to do with, because, 10 years ago, together with the government of Costa Rica and the CLAC, we were invited to, I think it was the Maastricht COP5, I think it was, and we had the opportunity to learn from the experience of the Aarhus Committee. And at that time, there was no discussion about the human rights, the rights of those people who were being threatened. So our region is the most dangerous around the world. So I would like to ask Jonas, and I am going to listen to this session again because of all the lessons that Paulina and Julieta also give us. So my question to Jonas is, how did you think about this topic, since in Europe the situation is different, but there is also attacks against people who defend environmental rights? And now we have the question from Nicole, the representative from the public.
To try, but I can't. I will ask.
Gracias. Estamos acá con...
Thank you. Our question, and first I'd like to thank all the panelists, but my question has to do with the public and how dialogue has been with the committee, and any lessons learned from in that regard, and any recommendations that you might have as to how to build capacity and information so that the public can also have a dialogue with the committee in an informed way, but also in a proactive way. In a way, we know that this is a challenge, not only regarding technical knowledge, but also because of the recognition of the different elements, perhaps in the territory or local elements. So about your general vision as to how we could support the committee to strengthen these capacities, or to foster strengthening of capacities. Thank you. And we have a question from Antigua and Barbuda.
And I'd like to thank all the panelists for their enlightening discussion. I just think I need to clarify something that was said by my colleague. When the professor spoke about companies and that the convention doesn't dampen investment, I agree, that's good. And he said that businesses appreciate clear rules to follow, and they're very much into green and the human rights element. But the fact is, when they come to countries in the Caribbean, Latin America, and Africa, their whole attitude changes, because the power base changes very dramatically. And one of the things I'm very well aware of is that companies can hide behind veils of companies. You have multinational companies who own this company, that company, and sometimes it's very hard to know exactly who you're dealing with, because you don't know who's a subsidiary, who's the parent. They can really hide and send you around in circles. So I was just wondering if, when we are dealing with the access to information through the committee, is there any way we could look at looking at the shareholders, where sometimes that will give you a better idea of who owns what and where the money interest lies? Because many of the people who are looking to be on the committee are lawyers, and they will understand the complexities of trying to find out who owns what. And as we know, it can take years to find out who owns what. And the thing is, companies can always be changing their names. They can dissolve, set up tomorrow. And it can become a very frustrating game to find out who actually owns what. So I just thought I'd bring that to the table. Thank you.
Thank you, Maureen, for your question. Very important. So if you want to start, Jonas, and then we continue with the other answers.
Thank you very much. And again, very relevant questions, I think. So the first one from Chile: how did we address protection of environmental defenders, so members of the public, when they were harassed, persecuted, or penalized? And I think here it's interesting, and as the Chilean delegate pointed out, the Århus Convention does not have such a bold provision on protecting environmental defenders as the Escazú Agreement has. There is a provision, however, in the Århus Convention that the parties must ensure that members of the public are not harassed, persecuted, or penalized when exercising the rights of the convention. And the Compliance Committee received cases addressing that. And it was a very special case, very important case for the committee to sort out how are we going to deal with this. And as part of that, since the convention only has this short provision, we were needed to find out a way also to examine whether a state has acted in that way, to identify that there have been some kind of harassment or persecution or penalization, also to make sure that it is linked to matters under the convention, and that there was no proper reason by the party to act against these citizens when they have, in this case, they have demonstrated, and even though the convention doesn't say anything specifically about the possibility of members of the public to be active in expressing their views more generally, the committee saw that this is an essential part of exercising the right of the convention too. So the Compliance Committee in this case found that the party concerned had violated the convention. This was brought to the meeting of the parties, and we were reporting all our findings to the meeting of the parties, and the parties meeting of the parties endorsed our findings. So we had recommendations on how this party was supposed to act to get in compliance again. So we did this, but again, the awareness during the drafting of the Escazú Agreement and the linking between human rights and participatory rights was much clearer. And I think also, as has been pointed out, while we have these problems in Europe and Central Asia and Caucasus, I think the experiences in Latin America and the Caribbean of these issues is also greater. But this is how we addressed this. And we were, of course, I was very pleased to see that this was a big issue in this region too. Now, I would say, I'm not sure that the Secretariat of the Århus Convention of Parties would agree to that, but I think the Århus community was inspired by the Escazú Agreement in emphasizing this even more. So at the last meeting of the parties, a specific new position of a special rapporteur on the protection of the environmental defenders was agreed in Århus Convention. So this has also been, I would say, highlighted even more since then. Then to the representative of the public, how to build capacity and how to make sure that the public can engage. And it has been a fundamental part since the beginning that not only the Compliance Committee's work, but the convention as a whole depends on active civil society organizations. I can say as the chair, I shouldn't say it's one of the worst things, but it was very difficult if we received a poorly drafted communication. That was much more time consuming for the committee to deal with, to make sure that we understood it rightly, to make sure that the party concerned can respond in an adequate way. So we spent quite a lot of time, and we were supporting, or not we, but the Secretariat were also supporting networks of NGOs to teach each other how to act vis-a-vis the committee, because that's helpful for everyone. I want to stress that engaging the public, this is not a zero-sum game. Just because some actors can get more power doesn't mean that other actors like governments lose their power. Actually, public participation could improve the legitimacy of government's work. So I think this has been not the controversial issues among the states either, that there is this understanding that promoting the work and the capacity of civil society organization is to the benefit for all parties involved. And I hope that that will be the case here as well. Then coming back to the point by Antigua and Barbuda, I think this is very relevant, and I'm fully aware of some of these consequences. If I should say something where this could be supportive, to be a bit optimistic but not overly naive, I would say that we see this as a development with the Århus, now Escazú Agreement, in parallel to the development of human rights institutions. For instance, the Inter-American Court of Human Rights gave an important advisory opinion to Colombia a few years ago, also about participatory rights. The European Court of Human Rights has developed in the last 30 years after Rio 1992 on jurisprudence on these points. Possibly, at least, I think this could help providing like a level playing field. it will at least make it more difficult for companies to say we go there because they don't have any access rights or participatory rights, if you can resolve that. There is an interesting development in the European Union right now, which I think builds on this as well. There is now a proposed legislation, a directive on sustainability due diligence, which puts requirements on companies that are based in Europe to act with due regard to environment protection and human rights, not only when operating in Europe, but when operating all over the world. And the new rapporteur on protection of environmental defenders is also now looking at the possibility of making or reviewing what's happening with these states if companies from these states do not perform properly when they come, for instance, to the Caribbean and so on. So I think this is important. Finally, what I think, there's nothing to prevent, engage business in the capacity building. You can invite business to meetings to explain, to teach them how to work here. And you can find that there are some corporations who will be ahead. They will be pushing, some will be behind. So I think there are some good opportunities that this could be helpful in this respect. Thank you.
Thank you, Janice.
Gracias, Presidenta. Con respecto a los puntos levantados.
Okay, something that is important is that the committee has a technical secretariat that is empowered and that has resources so that it can fulfill its task. It has to analyze information, it has to systematize information to deliver it to the members of the committee so that the members of the committee can hold sessions and meetings. And it's very important for the committee, the implementation committee, to remember that it doesn't have a budget. The budget is the budget of the secretariat. And therefore, if you want to provide the implementation committee with the capacity to undertake actions, it is important for the committee to have access to the budget and for the secretariat to have a budget to do its work, because otherwise it becomes sort of a thwarted expectation to have access to an effective and efficient committee. We need to take into account that even simultaneous interpretation of services are costly, and therefore it is fundamental to address the uncomfortable topic of financing. And particularly if the committee is going to have specific funding, if it's going to be sort of an item allocated within contributions for the committee to work with an active technical secretariat. So that's one thing. Secondly, the Implementation and Compliance Committee has an advocacy and education role, and it has to meet with the state parties, and it can also meet with observers, with the public. In the last session of the Implementation and Compliance Committee of the Minamata Convention, NGOs and observers were received, and their comments were very valuable for the discussion that then took place about national information that had been reported by the countries. And so also the Implementation and Compliance Committee acts as a forum to facilitate lessons learned among countries that had strategies that worked well, and how those countries can support other countries, and how to have bilateral cooperation as well to develop capacities among countries. So the committee could serve for that purpose as well. And in addition, it can create synergies with other environmental multilateral conventions or with other implementation and compliance committees. We have the Basilea Committee, the Basel Committee, the Rotterdam Committee, etc. And then the transparency of what is worked on by the committee. Everything that the committee does is transparent. It's not confidential, and therefore, even though there are some deliberations to adopt decisions that are behind closed doors, the outcome, the results of those deliberations, everything is public, and it has to be reported to the Conference of the Parties. And one last thing regarding what Antigua and Barbuda said. One important aspect is that almost all the financial institutions, international financial institutions, demand minimum standards of compliance regarding human rights, environmental protection, and therefore they have mechanisms to be able to address any deviations if there's suspicion that a project funded by the World Bank, for example, or by the IFC funds, then there are mechanisms to resort to that institution, and the institution has to approve, and before approving the funding, it has to conduct an environmental due diligence. So funding and financing is a way to be able to demand minimum standards of transparency for investments to be conducted in the country. Thank you.
Briefly, regarding capacity building, the public and organizations, we should think in a specific line of action. A work committee in advocating for the agreement, in creating technical capacities for the agreement to be used in an effective manner. The committee should devise a line of action or line of work, and the Secretariat should support this capacity building work. As my co-worker was saying, fellow panelist was saying, submit effective communications, and when there's adequate information submitted to states, that's an invaluable source of information. It's critical for committees to be able to adequately assess the situation. I think that needs time. We need to think about a capacity building program and allocate the resources that are needed for that. And then in relation to what Antigua and Barbuda has said, I want to say that from the international law of human rights, there's a development regarding how companies are accountable in terms of human rights and the environment, a long history from the 70s, but over the last years, significant progress has been made. They are more substantive, based on the United Nations principles in terms of human rights. This mechanism of respecting, redressing, and protect, including the due diligence in terms of human rights for companies. I'm not going to go deep into this topic, but I should bring up all these developments in order to hold companies accountable relating to human rights. Lastly, there's a treaty being developed regarding companies and human rights. Many drafts are being made right now, and its purpose is to create a stronger link for companies and also to create forums for victims to file adequate complaints against companies. Trying to find the culprits. That's all. Thank you. So we are going to take one additional question from Guyana. And let's try to be as brief as possible in answering them so we can go out for lunch and then come back for the afternoon session.
Thank you, and sorry to be the obstacle between you and lunch. But since I'm speaking for the first time, I want to take the opportunity as well to thank the President and people of Argentina for hosting us in this beautiful city of Buenos Aires. And of course, the Secretariat and presiding officers for facilitating our attendance. This may perhaps be linked to capacity building. When we look at the agreement, there are significant majority of the obligations are for the state parties, for the competent authority. But as we know, in engagement, there should be some sort of responsibility on the part of the public in terms of how they engage and how they request information. Is there any example in the EU or with the Minamata Convention how that was implemented to ensure that this is a collaborative effort and it's not just a demand, and that whatever is demanded, governments must respond to? It must be collaborative. So we'll be grateful if we can get some inputs into that. Thank you.
Thank you very much for the intervention. Quick round of answers.
Thank you. Well, of course, this is an important element also, how members of the public act. And I want to make a distinction between how we see in the promotion of the convention how civil society organizations, members of the public have acted. In our cases, before the committee, in other task force where they have been active in capacity building, I mean, they should act responsibly and in good faith. And of course, if we see that there was not good quality or proper action from a member of the public in front of the committee, that person or organization would know so very quickly. However, as regards access to information, the right to participate and access to justice, these rights, I would say, in a sense, are unconditional. They are not without limits. There are certain restrictions to them, but they do not come with an obligation to act in a certain way. Well, of course, if you ask for information in a way that is not understood, if you ask for too much information that simply cannot be dealt with by an authority, or in some such way, there could be reasons to do so, to limit access or to explain that we cannot deal with this request because it's not possible. If you ask for any documentation there is relating to the environment by an authority, that wouldn't be possible to deal with. So this if that is seen as an abuse, yes, you could deal with that. But it doesn't come with a responsibility to only ask for a certain number of times per year or something like that. On access to information, it is even clear in the Aarhus case, and I think, but you can correct me if I'm wrong with Escazú, the members of the public who ask for information do not even need to explain why they want it. Also, it's not limited to members of the public among the member states. So if any one of you would like to know how does the Swedish Chemical Inspectorate deal with mercury, for instance, you have the right to request that by email and without explaining what you're going to do with it. If you're going to find a way to ignore national rules or to promote something or help business or fight business, that is not an issue. You should have the right. Then there are, again, limitations if the request deals with security issues, international relations, certain matters of companies' economic situation, privacy. I mean, then you can draw lines. But it doesn't come with other forms of responsibilities. These are rights.
Gracias.
Regarding Minamata, it's important to bear in mind that the participation of observer is within the rules of procedure. Observers should participate in good faith and in a respectful manner. In the Basel, Stockholm, and Rotterdam conventions, the secretariat for those conventions created some rules of conduct to prevent harassment by observers to national delegations. And those rules of procedures and rules of conduct are actively disseminated. There are webinars, workshops, and all of those who sign up to participate in the triple COP of Rotterdam, Stockholm, and Basel. The observer should abide by those rules of conduct. In the case of Minamata, we still don't have those rules of conduct. We are thinking about it. If that is relevant, the Minamata Secretariat is doing that, but respectful treatment should be there, whether it's the public, whether they are national representatives or delegates, also officers of the Secretariat, as well as representative of the private sector from the public. Only can constructive agreements be reached if there is collaboration and respect. So the rules for the operation of the committee are going to be very important. So I encourage the Escazú agreement to agree on these rules of procedure and rules of conduct of those stakeholders and participants. At least in the United Nations system, there are rules of conduct that are not written, but organizations must act responsibly in good faith and not submitting false information. These are basic issues. But we can see this through the interaction with organizations and the affected or victims. In general, organizations act in good faith. Most of them do that. So I don't see an issue here. At least in my committee, this has not been a problem. There are rules for tackling specific cases, depending on what case it is. We analyze if it is within the scope of the treaty, but the committee has the powers to reject the case if there was an abuse, a procedure, or abusive procedure. In the United Nations systems, this has not been a problem from my experience. That's what this is my personal experience. So thank you very much. The interventions have been very fruitful. Let's have a big round of applause for the wonderful presentations and interventions. Thank you very much. Now we have a lunch period a little less than 1 hour, so we have to be back at 14:45 because we have a lot to cover. Next section is about implementing the agreement at a national level. So, thank you very much.
Bueno, si nos vamos acercando en unos minutos ya vamos a...
Okay, I know that it's hard to come back after lunch. Also because the morning was very busy and last night, but we need to go on.
Bueno, vamos a comenzar entonces.
Okay, so we're going to start. Please, let's lower the music. The session that we have today is a regional dialogue to strengthen capacities for national implementation. I think that many of the remarks and questions that we had in the previous panel were about the experience of the compliance committee, and they were related to the challenges that we have in the different countries to implement the Escazú agreement in our territories. One of the main commitments that we have, that we've undertaken when we organized this extraordinary COP, was to move forward not only fast with implementation, but also to do it in an assertive way with all the tools and reaching all the territories. And something that is also very important that has to do with one of the articles of Escazú is to guarantee the full and effective implementation in Latin America and the Caribbean of the rights of access to environmental information, public participation in the environmental decision-making process, and access to justice in environmental matters, and the creation and strengthening of capacities and cooperation, contributing to the protection of the right of every person, of present and future generations, to live in a healthy environment and to sustainable development. In this way, the purpose of this session and of the joint work that we have as state parties is to have broad dialogue intended to strengthen these capacities, that we can learn from what other countries are doing, and also we can learn about what we can correct from any mistakes, to present a guide for implementation of the regional agreement. And then I'll give the floor to the Secretariat so they can discuss this topic and then exchange experiences about the progress that has been made by many countries. And we're going to listen to Argentina, Chile, Ecuador, Mexico, Uruguay, and St. Lucia, among others. This is going to be a long session, so it's going to be organized in different segments. We're going to start with a regional issue, and then in between we're going to have a cup of coffee, because as I said before, the afternoons are a little bit harder to keep active, so we will have time to rest, and then we will have to come back, of course. So next I'm going to give the floor to the Secretariat of the Escazú Agreement, which is going to have 10 minutes, and I'm going to be a little bit more strict with time, because otherwise we're going to have a very, very long afternoon and evening. So you have 10 minutes, Carlos, for your presentation. Thank you, thank you. And I have two restrictions. One is a time constraint, and the other one is the interpreters that force me to speak slowly. So I wanted to say three things that are the core elements that the Secretariat has been working on, not in the last year, but in the last years. And actually not only the Secretariat, but also a broader team of people that contribute to the strengthening of capacities and cooperation. One is the guide, the other one is the observatory that I already mentioned before, and finally the roadmaps that we will discuss with the specific examples from many countries of the region. And so regarding the implementation guide, we have distributed, and you probably have a copy, those of you who are around the table, but we have more copies for anybody who would like to have a printed copy. It's also posted on the website. That is the guide for the implementation of the Escazú agreement. So the first thing we need to do is to recognize everybody who worked on this, many of those who are present today, because this guide was fueled by all the discussions that we've had since 2012 and even before that. Many authors are here today, and Constant Nalegat, who's here today too. She was one of the lead negotiations during the entire process, and also she was not just a lead negotiator. She was there in Rio +20 to be able to. She was able to get the declaration that gave rise to this process at that summit, because that declaration was signed by 10 countries. And then I want to recognize Marcelo Causillas, who was another essential actor for this process, and both have essential knowledge regarding the content of the agreement and of law. And Marcelo presided over the technical group of legal review when we drafted the agreement. And then I'd like to recognize Daniela Andrade, a lawyer, and she was one of the representatives that was elected, one of the public elected representatives, and this lawyer from Jamaica helped us better understand the different aspects of case law and the legal regulations of the countries in the Caribbean. So, of course, let's bear in mind that the Secretariat that I'm heading now, and with Anis Barrio, Gabriela, Andrea, and everybody who's here today, they all participated directly or indirectly in the preparation of the guide. So that was the first group of people who participated. But obviously, having a guide for implementation, particularly the first one, needs the participation of many others. And therefore, the guide was subjected to a very broad review. Weston Anderson, who is a judge of the Caribbean Court of Justice, Silvia Capelli, Concepcion Escobar, many of those who have been in the process, who were the experts that allowed us to solve any questions that we had, and also our treaty office headquartered in New York, or Mr. Yornos as the Human Rights Rapporteur, the first special rapporteur for human rights and environment matters of the UN, who headed the compliance committee of Aarhus. In addition to some experts in law, Mario Peña, Mrs. Muñoz, who have accompanied us. So this was not enough. The guide was subjected to a public consultation process where we also received many contributions from many organizations, including organizations that were very important for the region, like COICA. They sent their comments, and then others who are also recognized. So the guide was prepared because after we adopted this Escazú agreement, we started to conduct many webinars during the pandemic where we discussed the content, how to interpret the content, how it should be disseminated, and there were many questions about the agreement. And therefore, there was much material that we decided to sort of translate in this guide, and we are sure that with the progress that we make in the implementation of the agreement, we can improve in several successive editions of the guide. And I wanted to mention a few key aspects of the guide. The first one is that it had into account that the authentic texts of the treaties are both English and Spanish, so both versions were reviewed. The second aspect is that when you read the Escazú agreement, you have to read it in a comprehensive way. Of course, you can go step by step, article by article. You have to have an overall perspective and the cross-cutting elements that can be applied. And then another thing that I wanted to mention is that we should take into account that the Escazú agreement is an international treaty, and therefore it's legally binding. But when we read the agreement, the nature of the words is different, and there are stronger obligations and perhaps more lenient obligations on the basis of the language. So that review was one of the essential elements as well, because this allows the parties to be able to move forward in the implementation of the agreement, because as we said, this is a minimum standard. It's not a ceiling. So something that is also important is that the interpretation of any treaty has to be done in good faith and in accordance with the purpose of the treaty. And that was the spirit under which we reviewed the language and the text of the agreement. And also, we reviewed all the minutes and all the reports of the negotiation rounds to see if there was any question or any doubt why that language was there. The purpose of the Escazú agreement is to have a national implementation, and the core is for it to be effective in national implementation. So when you see the agreement, you're going to see that it's divided, or it has a structure that includes an introduction where it tells a story about the process so that everybody who reaches the agreement can understand how it works, have a general framework, and so how to read the agreement, and then the cross-cutting issues that are many. And then we have a structure that has chapters and sections or articles. The background, the cross-cutting elements, and the analysis article by article are the elements that you will be able to find in the guide for the implementation of the agreement. For us, it's been a pleasure to have a prologue written by the Secretary General of the UN, because our General Secretariat in New York continues and follows up on this process and has supported us during the negotiation process, and he also supported the publication of implementation. So that was the first thing that I wanted to mention. And about the observatory, we have a leaflet about the observatory, and it's important for you to help us to continue populating the observatory. This is an exchange center that where we can establish, or we can exchange case law, treaties, any news in legal regulations, and for it to be helpful for everybody, it requires the effort of everybody. And then making a brief introduction about the roadmaps. The purpose of the Secretariat was for the countries to start moving forward in the national implementation, but that was also an objective by the countries, so it was a twofold objective. And in many cases, we had similarities and we were working in the same direction. And the Secretariat, to be able to facilitate some consistency, understanding diversity and the specificities of each country, the Secretariat designed a small roadmap that would allow for making national work more visible, and also to provide similarities between the steps to be able to create regional synergies, to allow for cooperation. So this is a cooperation agreement, and therefore being aware of the needs, and not only the needs, but also the capacities of each country to support others, is an element that is essential. And therefore, in that roadmap, in addition to working on the national basis or basic lines to know what there is and what there isn't in each country, it is also important to have a mapping, because this is an agreement that looks for cooperation. So to map the public sector actors and other sectors that don't belong to the public sector that can also help implement the agreement, to facilitate the interinstitutional coordination and to facilitate broader coordination that would support the national governance of the Escazú agreement implementation. So hopefully this process can have maximum participation at the national level. And as I mentioned, in the process of advancing that roadmap, for the Secretariat, it's very important to identify not only the needs, but also, and once again, the opportunities that each country can offer to support the others. So that with these two sides of the same coin, in the future, we can establish systems where, one, there could be donors that can support certain countries in implementing certain things, and also there will be countries that can help other countries or perhaps generate threefold or bilateral cooperation. So the roadmaps are going to help us for that. Right now, we will hear Argentina, Chile, Ecuador, Mexico, St. Lucia, and Uruguay. And for us, it is very important for the 13 countries to move forward in this direction. And then to conclude, and so that I'm not scolded by Cecilia, I wanted to mention that, for example, Argentina, in this process, has conducted 7 training seminars with 200 people involving stakeholders from the 3 branches of government, civil society organization, the academia, and the judiciary. And Chile is the same. They have had very broad stakeholders from civil society organization, more than 540 people, 200 from the 3 branches of government, and then they will tell you about all the national actions that they have implemented. Mexico has been very active in dissemination, more than 6 dissemination actions we counted, and training actions that have also been very successful. I think it was 5 with 500 people that were involved in improvement areas. St. Lucia has been very active in identifying room for improvement or areas for improvement and establishing recommendations, and Uruguay has made progress in that analysis as well, because recognizing what we need is the first step to be able to start moving forward. And so I will leave you with now, but the Secretary, of course, has a purpose, and that is to move forward in the national implementation, and therefore you have our support, and also the support of many other partners that I would like to mention at some point, including several colleagues from the UN system, from the President Coordinator's offices, the High Commissioner, UNDP, the World Bank, UNEP, and several other actors and stakeholders that I hope I don't forget. They have supported these national implementation processes, and we hope that in the future they continue to do so in the countries that have not yet worked with us. And I would like to invite the rest of the system to join, because everybody can contribute, particularly in the implementation of the Escazú agreement. So with this, I would like to finish. Thank you, Carlos. Well, you were over the time for a few minutes only, so thank you for the tools that you're delivering or you're giving to the Secretariat. I think it's very important to have support from the state parties, and so I echo the words of adding other bodies and agencies to the implementation of the agreement. And next, I'd like to give the floor to Mr. Chamberlain Emmanuel. He is the head of the Sustainability Unit of the Organization of Eastern Caribbean States, who's going to show us a concrete example of the implementation of the agreement. You have the floor.
Thank you, Madam Chair. And I want to also say thank you to the government and people of Argentina for excellent hosting, and to the Secretariat for making it possible for the OECS to participate. Good afternoon, everyone. The Organization of Eastern Caribbean States is an international governmental organization established since 1981 by the Treaty of Basse-Terre, which was revised in 2011, to promote and facilitate regional integration and cooperation amongst the small island developing states of the Eastern Caribbean, including in areas of human rights, social well-being, economic development, and environmental sustainability. The sustainable development aspirations of the OECS member states and the broader CARICOM region are heavily dependent on the integrity and sustainable use of critical and fragile natural assets, ecosystem services, and biodiversity in the marine, coastal, and terrestrial spaces. A primary objective of the OECS is therefore to facilitate the sustainable development of the region by maximizing the benefits from the collective space while ensuring capacity for environmental management and resilience. Hence, the revised Treaty of Basse-Terre requires member states to implement the St. George's Declaration of Principles for Environmental Sustainability in the OECS to minimize environmental vulnerability, improve environmental management, and protect the region's natural, including historical and cultural resource base for optimal social and economic benefits for member states. The revised St. George's Declaration, dubbed SGD 2040, now includes recognition of and reference to the Regional Agreement on Access to Information, Public Participation and Justice in Environmental Matters in Latin America and the Caribbean, Escazú Agreement, which aligns seamlessly with the enduring principles of the St. George's Declaration, including the Escazú Article 5, Access to Environmental Information, Article 6, Generation and Dissemination of Environmental Information, and Article 7, public participation in the environmental decision-making process. It should therefore be no surprise that 5 of 6 eligible OECS member states have ratified the Escazú Agreement, 1/3 of the 15 parties, and are very active in its promotion and processes. We celebrate Grenada's most recent ratification and anticipate that the Commonwealth of Dominica will soon complete this process. The OECS and ECLAC have been collaborating on an enhanced program of action in the Eastern Caribbean, including technical support towards the establishment of a regional environmental information system geared towards facilitating reporting obligations of the Escazú Agreement and, by extension, the St. George's Declaration, the 2030 Sustainable Development Goals, and other key multilateral environmental agreements. This aims to enhance national and regional accessibility to data, improve coordination, and promote data sharing and co-production of information within the region. We are particularly pleased with the collaboration with ECLAC as the process employed ensures the establishment of an ecosystem with strong capacity, ownership, and sharing at the national level, thus overcoming key hindrances to reliable and accessible environmental data and information in the region. ECLAC has worked with countries to complete the Environmental Statistics Self-Assessment Tool, ESAT, to facilitate workshops to build capacity on relevant indicators and methodological tools, and is piloting exercises with Antigua and Barbuda and St. Lucia to identify relevant common cost statistics and data gaps, with focal points from respective environment and statistics agencies. The OECS is also working deliberately with complementary initiatives to ensure a reduction of duplication and leveraging of synergies and resources. We are therefore confident that the region is well on the way to ensuring the institutional capacity and tools needed to implement Articles 5, 6, and 7 of Escazú. Additionally, in collaboration with the Caribbean Natural Resources Institute, with its extensive indigenous civil society expertise and networking, member states, through the OECS Council of Ministers, have now considered and endorsed a stakeholder engagement strategy for civil society and private sector to support delivery of their commitments to a whole-of-society approach to environmental governance and management in the OECS that addresses the needs of citizens and leverages the talents and perspectives of all sectors and at all levels, and now serves as a regional standard with key steps and guiding principles to undertake strategic, meaningful, and effective management. Finally, Chair, we applaud the inclusivity of Escazú and the COP processes in ensuring that indigenous peoples, youth, women, civil society, and multiple languages and cultures have a strong voice and a seat at the table. We note that Escazú Article 11 on cooperation promotes particular consideration to small island developing states, encourages partnerships with states from other regions, and recognizes the importance of regional cooperation and information sharing to combat illicit activities against the environment. I am therefore mindful to mention that the OECS member states include 5 and soon 6 non-independent states or overseas territories who also ascribe to the St. George's Declaration and align with the aspirations and values of Escazú. I therefore encourage the parties and the Secretariat to consider and explore appropriate modalities for engagement of non-independent seats, notwithstanding their current political status. Chair, I thank you for this opportunity and wish you and the parties much success in this COP and for the implementation of Escazú. And the OECS will continue to support our member states in their participation and implementation priorities. I thank you.
Thank you very much for your intervention.
Now, we'll have the comments by 3 countries, Argentina, Chile, and Ecuador. So Argentina will start. Jessica Motok. She's a national director of Climate Change Secretariat. Also, she leads the development and sustainable development and innovation. She's my boss, so to speak. Jessica, you have 8 minutes. I'm going to try to be brief. Good afternoon. Can you please show my presentation? When addressing implementation, we made 2 divisions. The first one is what was our compliance status, and the second was to identify room of improvement and prioritize actions. For that, we designed the first stage, in which we had a cabinet and 2 participatory stages to arrive at a prioritization for areas of improvement. We made some regulatory survey at subnational, national, and global level. Then we included primary information. We met 31 different stakeholders from different relevance about dealing with different topics, academics, NGOs, private sectors, and the national government. After that, we enabled a form for the provinces to enter their information. All that was translated into a document, and we designed a participation strategy given to a virtual public consultation. So we got 34 prioritized actions. They were uploaded on our website, and I'm going to mention some of them. 6 pillars. Escazú, and the 6th one about governance. The information pillar, 2 prioritized actions are what is the information like, the information that we deliver with adequate content. In Argentina, we have information access laws, but the issue is that its content needs to be accessible and useful for the people requesting it. Another point is vulnerability group access to information. Here we are designing, together with the Office of the Ombudsman, and also working with the provinces, to create the centers for access to justice that are distributed in the countries. We can reach the territory and the vulnerable groups through these centers. Training them is also important. The justice pillar is about broadening the access to state mechanisms and other institutions, and they are free of charge. They can access them for free. Then promoting open participation. Another topic is early participation within the agreement. You can see that we need to strengthen participation at its inception when doing public policy and designing them. So early participation is not yet defined, and we don't have guidelines, but then I'm going to talk about this. Regarding the defender pillars, the prioritized action is to start, the need for more systematized information and define the status of our defenders. And for that reason, we created an observatory. Regarding training, a priority training area where national government teams that are related to the Escazú agreement. The other point is to have a web page gathering all the information and from which we can access different web pages with different type of information. In terms of governance, we want to design an interjurisdiction and institutional coordination and to design a governance structure. Now, in this second stage, that's where we are. Point number 2, the first thing we did is to design a governance and coordination system. We completed the first stakeholder map to make it complete and broad from those public and private stakeholders that can take on responsibility and make commitments to support the agreement implementation. We designed the institutional and interinstitutional system with those stakeholders that are related to the agreement. I'm going to show you our participatory construction strategy. That's our plan. Once we have all the relevant information, we are going to create our implementation plan. This is our proposal for the next step to conclude the second stage, the dissemination stage, so that everyone can know the channels to get engaged and for joint work. We want to have dialogue tables that can be synchronic and also distance or remote dialogues, and then in-person visits to the territory, and having a virtual proposal box to receive or to deliver proposals or relevant proposals. And then the regional workshops as well. Finally, where we are right now, or what we are doing right now, the coordination and governance systems with all these actors, the training sessions we held, and this is something new. Next Tuesday, we'll have the first training course in centers for access to justice. We are going to train legal advisors that are going to provide their advisory services to communities and peoples on the territory. The 5th action plan of open government, it's a plan for 2023 and 2024. It includes an environmental commitment. This is the Escazú commitment with different milestones. We have achieved the first one, that was to have a website. I don't know if you can see it down there on the page. It's Escazú Agreement Environment. There you'll find all the information. You'll see all the pillar information. You'll see infographics, videos, papers, documents, links to consultations. So if you want to know what I'm talking about, you will find it over there. All the territorial access, all the jurisdictions, their information, you know where to find all that. And then early participation or engagement. When we knew that we had to create some guidelines, we realized it had to be jointly created with all participants. So we had different meetings. We got together with different people. And the third meeting was held at midday here in a room of this hotel with national focal points, and the second one with NGOs and the academia, and the third one was kind of a bigger or larger, and we have some others in order to deliver the guidelines that rule the early participation. The outcome is really hard to quantify, but it's really valuable. All the people that were interviewed and participate, they are focal points that were engaged in our plan, created this link, and they give relevance to the agreement. And it's really nice to see how this network is being created at different levels. So thank you very much. Thank you. Thank you. Now, she used up her 8 minutes sharp. Now, Chile has the floor. Maximiliano Proaños, he's Undersecretary of the Environment Ministry, and Valentina Duran, Director of the Environmental Assessment Service.
Hola a todas y todos.
Hello, everyone. Good afternoon. I'd like to thank the Argentine government for hosting this, for welcoming us, and particularly I'd like to thank UNEP and ECLAC for their support and their follow-up at the beginning of this implementation process, of our implementation process. And I think the entire delegation of Chile cannot hide the emotion that we feel, because now we are a state party. Last year, in the first COP in Chile, when was that? I don't even remember when it was, but we said, we hope that next year we can cross the Andes as a state party to the agreement. And this was a priority for our government, and that's why we're so happy and very proud of being part of the Escazú family once again. This is an agreement that I think we need to be proud of it as Latin America and the Caribbean, as a region, regarding what it means to take charge of an important problem that is shared regarding strengthening our environmental democracy. And so this is a debt that we have as a region, to have effective integration instruments. And I strongly believe that this agreement has that potential, the potential of becoming an increasing regional integration instrument. And that's why I'd like to reaffirm our commitment. We need to play a significant role in that process. So the first bill that we sent to Congress last year, when we took office in March last year, was precisely the Escazú Agreement. And we were able to achieve it. We had cross-cutting support from different sectors, and so it was approved. And this showed the commitment of our government with the environment and with human rights, and with the strengthening of democracy and governance through transparency, corruption control, and accountability. And it also showed the commitment with multilateralism and cooperation, such vis-a-vis global challenges like climate change and the loss of biodiversity and plastic contamination. The support in both houses of Congress allowed Chile to approve by Congress in 2022. In September 2022, we became the 13th state party of this unique environmental treaty in this region, in Latin America and the Caribbean. And as we said here, this is a unique treaty worldwide as well. And the truth is that it hasn't been easy. It wasn't easy to get to this point. As Michael said in the opening remarks yesterday, it's not enough to be a state party. We need to be ambitious in the implementation, in this implementation process. And we, as a country, are undertaking this process with a set of actions that can be grouped under 3 pillars. The first one has to do with training and dissemination, and then the identification of management measures, and then the planning of a participatory implementation plan, and it's called PPAY in Spanish. That's the acronym in Spanish, and this is translated in some specific things. We trained more than 1,900 civil servants at the national and local level, and citizens in general through online seminars and workshops. We also had specific actions with public institutions at the national and subnational levels. We appointed 24 ministerial focal points that define specific actions to be able to move forward with participation, access to environmental justice, and dissemination. And as I said before, we have identified as a core element the development throughout this year and the first quarter of 2024, an implementation plan, actually a participatory implementation plan that is intended to assess the gaps, the opportunities, and the priority measures for an effective and full implementation of the Escazú Agreement in Chile, focusing on vulnerable groups and persons. And here we can see the schedule that we have for the participatory process, and you can see it later because these documents are going to be uploaded on the website. So now we're in stage 2, that's public-private coordination, collaborative governance. So we finished with stage 1, which was the validation of the participatory design, and then we have the early participation stage. Then we have the proposal stage, or the preparation of proposals, and then the citizen consultation process. Stage 6 is preparing the final plan and the launch, and then during the first quarter of next year, we're going to start with the dissemination stage of the plan. And within the Ministry of the Environment, we defined more than 60 measures, the implementation of which improves the rights of access to information, participation, and environmental justice. For example, just to give you one particular example regarding information, we are developing updates in different information systems regarding recycling, strategic environmental assessment. We have a portal that is called SEIA, and we have a system for monitoring biodiversity. We also launched the website devoted to Escazú. It's called mma.com.cn, and we are planning on having a follow-up platform for the main international commitments on the environment. Regarding citizen participation, we updated the law based on Escazú standards. We're also creating a proactive transparency banner that allows us to enlarge the information dissemination, and we want to push legal and regulatory reforms, and we can include, for example, the environmental law, the environmental impact assessment system, rules and regulations, environment quality standard rules, and plans for decontamination and prevention for the purpose of adapting some aspects regarding access to information, citizen participation, and environmental justice to the Escazú standards. Regarding access to justice and the protection of defenders, we are preparing, and this is almost done, a protocol for the protection of human rights defenders and for judicial operators as well. This is being led by the Ministry of Justice and the Undersecretariat of Human Rights. And we're coordinating with the Foreign Affairs Ministry and the Human Rights Ministry. We hope this process to finish soon. And for that purpose, in January this year, the Ministry of the Environment, together with the Undersecretary of Human Rights of the Ministry of Justice, organized a focus group, the purpose of which was to have a dialogue space about the situation in Chile. However, since this is a problem that requires immediate attention and action, the presidential delegates for each one of the regions of our country, the Ministry of the Environment and Justice, together with our ministerial secretaries, has started a circuit for an alert circuit for defenders that will operate in the intermediate time until we have the protocol, and it's going to act if we receive cases of threats to defenders, environmental defenders. And we hope to find contributions in the participatory process that we're going to conduct this year to prepare a plan for the implementation of the agreement. The challenge in the implementation hasn't been only a task for the Ministry of the Environment, but it also includes all of our environment institutions and our Superintendency of the Environment, the environmental assessment system have undertaken an ambitious task, and that is to correctly implement the agreement. The Superintendents of the Environment, given its role as supervisor of the environmental documents, it is also key for the implementation of the agreement. And in this context, we highlight two essential measures. The first one has to do with access generation and dissemination of environmental information, based on which we are developing an internal policy of having clear and simple language and a gradual plan to publish files on the complaint portal. We have also a banner that is called Implementation SMA Escazú, that it describes the strategy and schedule, and the translation of the superintendency portal into indigenous peoples' languages. Also, access to justice in environmental issues or affairs. In connection with this topic, we are developing a guide to access environmental justice that is going to have information regarding the competencies of the superintendency, mechanisms of assistance to public, for example, models of submissions, for example, appeals, and a guideline document with questions and answers for the different actions undertaken by the Superintendency of the Environment. And this, for the next slide, I'd like to highlight that Valentina Duran, who has been one of the main defenders of this agreement in our country, is going to present. She's the executive director of the Environmental Assessment Service.
Thank you very much, Undersecretary, and good afternoon, everybody. I wanted to tell you all that when the Boric administration began, he had committed to get Chile to accede to the Escazú agreement. And even before Congress adopted the accession to Escazú, we incorporated in the 3 pillars, the management pillars, the environmental pillar, together with guaranteeing the environmental impact, as well as the incorporation of climate change in the assessment of the environmental impact. So the objective was that, and this was the way of carrying out our management efforts in the different pillars. And thus, to make this reality, we incorporated the Escazú agreement assessment within the management indicators, both in my position as in the heads of division position, and in the different service areas, also the regional divisions. Thus, we are forced to comply with certain actions. One of the first ones we adopted was in June, and this had a big impact. This was June last year, to produce instructions to apply the pro persona principle, ordering a favorable interpretation of the right of access and citizen involvement regarding the applications of citizens to gain citizen involvement or participation in environmental assessment. So this was a change, and it also meant the involvement of the officials that with the same resources could guarantee greater citizen participation, because they understood this was in line with the exercise of a right. We also started a process for strategic classification, a process of surveys that all officials were submitted to, requesting how they thought to apply, what is the best thing to do to apply the Escazú agreement. And one of the things, the outcome was that the internal structure couldn't cope with such a challenge. And that's why we created a new department, or rather, we recreated a department that had been eliminated a department for citizen participation, as well as the environment and consultation with the indigenous people. We will be finishing this survey, and the next month we will have it operative with important powers to be able to observe and define criteria to see how we can improve on an informed citizen participation. Besides that survey, which was very important for us because it meant the participation of our officials, there is an intense job done regarding the pillar about the assessment of first-grade technical tools. These are the drafting of guidelines and criteria for assessment. The private sector was involved, but at the same time, communities ask certainty. How are we going to guarantee that the environmental rulings and resolutions are complied with? We've made a big effort to make known and extend our workshops and training, which are, of course, free of charge, and they're open workshops. So we count among the attendants the citizens, the consultants, to analyze the guidelines of environmental impact. And in that context, we are also developing guidelines and instructions that we're putting together to improve the standards with the involvement of citizens in the system to incorporate the participation of the community in the different projects within our legal framework, because we need to launch public policies that are in existence, prevailing, and not to define them. So it's like browsing technical guidelines and elements, posting the answers on the websites. We have an email, which will become a platform through which we get comments and feedback about our documents. And we're also certified under ISO 9001. So this means opening doors to hear the different comments from the public. And we're also working at an academy, we called it Academia SEA, to strengthen training. And this includes a communicational policy that was always seen as very technical. It is technical, but we're trying to make it more citizen-friendly. And in the framework of this COP, there is already a network for inclusions of countries of Latin America, and we hope to work with it. We're talking of the SEA network or platform, and this involves the involvement of citizens in an informed manner, and something positive when it's about access to environmental justice is that what we can do is less visible, but it's existed, and we've demanded a change in the criteria whereby the service goes to court and defends the decisions, defending the service, the environmental committee, the minister committee, and this is how we use the pro persona principle to eliminate barriers when it comes to to a legal standing to sue. So whoever follows up on the endeavors in Chile will surely have noted the change in the criterion. All this has meant that what I told you about the instructions mean more text for citizen involvement regarding matters and productive sectors that we lacked before, as well as the amount of persons attending such workshops. And we've requested regional directors throughout the country to certify they themselves and their teams to establish how to disclose, the best way to disclose the existence of our project, because each community differs from the others, as well as the participation and dissemination of the news are different, whether this is an urban city, an urban part, or a rural area. So that's what we wanted to tell you today, the efforts that we're making in Chile when it comes to the Service for Environmental Assessment. Thank you very much. You see, I cheated. I cheated. I want them to stand up and show the jersey. I'm sure they're going to be very proud. Look at the Chile team. Look at them. Look at the Escazú Chile team.
Hice un poco de trampa porque como eran dos dije, bueno,
cheated because, you know, I said 16 minutes, 8 minutes each. But as they came properly clad and so happy that we finally have Chile with us in Escazú, the country deserved it, and we were also keen and eager to have them. And now I'm going back to my strict and stringent manners. Now it's Ecuador, Gabriel Monsalvas, Deputy Minister for the Environment, Water and Environmental Transition in Ecuador. Thank you very much. The authorities, government authorities, representatives of ECLAC, delegates from the different countries, and honorable elected representatives from the public. It's a pleasure to address you on behalf of the government of Ecuador to make known the main progress made in the Escazú framework. I want to start by pointing out that Ecuador was one of the 10 countries which in 2010 we signed the Declaration on the Enforcement of Principle 10 of the Rio Declaration on the Environment and Development, with which we started the preparatory process and negotiation process for the regional instrument, which in 2018 was adopted under the name Regional Agreement on Access to Information, Public Participation, and Access to Justice in Environmental Matters in Latin America and the Caribbean, or better known as Escazú Agreement. After participating in the negotiation process, Ecuador joined in as a signatory country in September 2018 and ratified it officially in May 2020. The Escazú Agreement was made effective in Ecuador in April 2021. Ecuador began the key versions for the implementation even before the agreement was made effective. And thus, in 2019, the priority was the process as one of the 10 commitments considered in the first action plan of the Open Administration 2019-2022. The commitment for the implementation of the rights to participate and access in environmental matters was executed in Escazú from August 20 to 2022 under the leadership of the Ministry for Water and Ecological Transition, and always counting on valuable international cooperation. With this prior work, the following outcomes took place: the ratification of the Escazú Agreement and diagnosis analysis about the consistency of the Escazú Agreement with a political regulatory framework in force, proposal by the Interinstitutional Task Force for Environmental Democracy as a place for governments teaching and following up on the implementation process of the Escazú Agreement, the ministerial agreement to create and establish this task force, and the roadmap for the implementation of the Escazú Agreement in Ecuador. For the Guillermo Lagos Mendoza administration, the implementation of the Escazú Agreement became a priority right from the very first, convinced that the promotion of spaces for the building of participatory capabilities, hydric sources, and making informed or guided decisions to benefit the quality of life of citizens, employment, and interdisciplinary education with a reduction of malnutrition, chronic child malnutrition, by accessing drinking waters in enough quantity and quality for our children. It is important to point out that our philosophy of rights in environmental matters is a national philosophy, because in Ecuador we recognize under the Constitution the right of the population to live in a healthy environment and a balanced environment, guaranteeing sustainability and a good life. All this is done in Ecuador. Thus, based on the work done by the Ministry for Environment, Water and Ecological Transition, in articulation with some 20 public institutions, we've made progress in the regulatory structure to implement the agreement. Thinking of the lessons learned in 2018 and strengthening methodologies and participation with local communities, the academia, and civil society within the 4 Escazú pillars. In these 2 years of actions, there are endless numbers of programs, initiatives, and projects that add up to the spirit of Escazú. Some of the most important ones are the pillar of the right to environmental information. We see, as an example, when you look at biodiversity as best practices related to the access to information, we made it official, the National Catalogue of Biological Objects, under a ministerial resolution dating back to 2021. This catalogue is the framework of notions and concepts for governors to learn about the national stock and assets by means of learning about biodiversity. One of the scopes of this catalogue is the regulation of the information and documentation centers recording biodiversity, whereby the citizen involvement and the scientific citizen involvement is fostered. In the same sense, we strengthen the information disseminated by means of the Equatorian pillar of the Ministry of Agriculture, the National Energy Ministry, the biodiversity data, the energy plan, and the platform adapting to climate change in Ecuador, led by the Ministry for the Environment, Water, and Ecological Transition. We've made progress redesigning the national system for national indicators, environmental indicators, and sustainability. On the other hand, the portal of open data makes available homogeneous and standardized data resulting from different publications. In environmental matters, we have 21 data sets regarding environmental quality, environmental preservation areas, usages, and the most made of hydric resources, ecological footprint, the surface of public domain, and territory, under the environmental and space definition. In the pillar on the right and access to environmental justice, enforcement of this justice has been strengthened administratively and at court, seeking to guarantee the rights of nature as well as the effectiveness of the rights to access. We can evidence, repair, and sanction actions such as rulings issued by the Constitutional Court in 2021, generating case law, and issuing an opinion on the consultation and participation in environmental matters under the standards of the Escazú Agreement. Case 1185, the Constitutional Court issues a ruling regarding an action for the protection regarding an irrigation project that might affect the Akepe River flow. This is in Santo Domingo de los Hachos. There we analyze the rights of nature, protection of the flow of the river, the environmental consultation, and the effective legal safeguard. In the case of Mona Estrellita, ruling 2520, that's a reference to analyze the development of regulations to protect wildlife.
These rulings evidence the need to include the provisions of the agreement, reform the current regulations, and strengthen institutional practices to ensure open and inclusive participation in the decisions about the environment. In case 4515, please could you wrap up? The reform of the water resources law was declared to be unconstitutional, and there's a new bill with the participation of at least 9,700 people and more than 4,000 civil society organizations. In terms of strengthening of the institutions, the state prosecutor created in 2021, with the support of civil society, a specialized unit for the investigation about criminal or crimes against the environment. Regarding the right to participation in environmental matters, as of today, we have a consultation process prior to the legislative process, calling upon indigenous communities, towns, and cities to provide opinions regarding the project to reform the environmental code in connection with the citizen participation process for environmental consultation. And this is to ensure their collective rights. The environmental consultation provisions would allow the community to deal with environmental matters, environmental licenses, with the participation of all citizens. Regarding the pillar of defense of human rights in environmental matters, in 2019, the Ombudsperson's office issued a provision to protect the rights of defenders of human rights and nature, the purpose of which is to establish prevention and protection actions for the rights of defenders on the basis of international standards in the environment or in the framework of the Ombudsperson's office scope of action. Finally, I'd like to present to you a document that describes the roadmap that Ecuador has developed to implement the Escazú Agreement. This document is the outcome and the result of significant efforts between ECLAC, to which I want to publicly thank civil society organizations, the government, and academia. The purpose of this document that you can find in your seats is to establish priority actions that are to be implemented and the timeframes for those in a framework of governance that can define the necessary interaction between the public institutions and between the public institutions and non-governmental organizations, the academia, private sector, etc. In Annex 1, which is at the end of the document, there is a diagram of the roadmap that was designed before this publication and which is its main input. For Ecuador, the Escazú Agreement is a visionary document that reflects the specificities of Latin America. Only a lively and participatory leadership can ensure a sustainable future for the current and coming generations. Thank you. Thank you, Deputy Minister. I think everybody has the text of the agreement, but before going to the coffee break, we have a few minutes for some questions and answers or remarks. So Argentina, Chile, and Ecuador, I'd like to give priority to the people that are in the audience. If somebody would like to ask a question, please raise your hand. We will take the microphone to you. You tell us where you're from and what your name is, and then we'll ask the question. I have some hands. Good afternoon. I'm Pablo from Jujuy, from Argentina, province of Jujuy. The question is for Argentina. I heard what Jessica said about the national implementation, and I want to know when you think this is going to be reaching the regional or the territories to be able to talk to the provinces, the municipalities. When are we going to see the agreement implemented in the territory? Now we're talking among the national states, right? I apologize. I understand that now this is the national discussion, but I think that Escazú is a tool to reach the territories and to have projects that are effectively implemented and executed in the territory, like the representative from Trinidad and Tobago specified. There is the need to have all these tools available, because that's where there is contact between affected people and the projects that are executed. Thank you.
Hola, ahí está.
Can you hear me? There are many things that we do to go to the provinces. First, we have a coordination scheme. This is something that we're going to validate soon in this series of participatory steps that I showed you in my slides. And regarding training, we have trainings that have been prepared, and we need to have or implement those trainings for the Centers for Justice Access and the ones that we have designed for officials. So that's already there. Those would be the two things we have already considered. And then Regarding the regional workshops, in the roadmap that I showed you, we think that for the second semester we would be organizing the regional workshops. I don't know. We don't think it's going to be in the 24 provinces. We are going to do one per region. That is to say, 6 in total. Here in the front, and then we have another question in the back. Good afternoon. I'm Florencia Cerchago, Director of Environment of the province of Tucumán in the northwest of Argentina. And we are participating in the process to prepare the roadmap with the Secretariat of Climate Change at the national level. And my question goes to Valentina Duran from Chile. I was very much interested in what you said regarding the consultation to public officials. Could you give us more information about how that was done? Thank you, Florencia, for your question. We need to say that the officials that participated, the participation of officials is something that we desire very much, and it was important for us to have this dialogue, even though we don't have that many resources. We can't get together. 400 people cannot get together, so we implemented a survey. And finally, we then provided feedback on the survey results. We prepared a report, and that was the way in which we organized it. We had a survey and then discussion processes in the regional centers and also in the executive directorate. We had a feedback process. Thank you. Perhaps during the coffee break, we could talk more about this. Of course. That was a good proposal. The coffee proposal, I mean. Good afternoon. I'm Joaquin Salinas. I'm 20 years old. I'm from Chile. And my question goes for Chile. And it's something that we have discussed with many people from the delegation already, but it's super important, at least for the rest of the people who are present here today, the public and the other delegations can become aware of it. And to clarify and to see Chile's commitment regarding defenders, environmental defenders. Unfortunately, we all know that Latin America is one of the most dangerous regions to be defenders, and it's a concern, a constant concern, in fact. Last week in Chile, I work in an organization that is the Escazú Foundation. We met we became aware of 3 or 4 cases of defenders who are being threatened through complaints by companies. They just file these complaints. And they ask for a significant amount of money, and in a way to threaten them. And many times these people don't have access to justice, and therefore the police forces are not receiving the complaints. The processes are not agile, and also they don't have the means to pay for a good attorney, and therefore, even though we know that there's a protocol that is underway by the ministry, and we also have this warning process, even though we have those elements, they are looking to have a good faith commitment of all the state authorities. Because even though there could be a protocol, perhaps the protocol is not complied with. And so how do you, as a minister and as a state, expect to act if there is no compliance with this process? That is my question. Because unfortunately, environmental defenders, even though Chile is making big efforts, defenders are being left out of the process. Okay, your remarks are very, very appropriate. And the challenge that we have identified from the very beginning of this implementation process was how to have effective instruments for the protection of environmental defenders in our country. Understanding and being aware of the fact that it was a problem that already had many and very serious cases. So first we identified that there is a protocol, and that is an instrument to allow us to have more effective institutions. But what do we do in the meantime? So that's why we developed this early warning circuit system, which is interinstitutional coordination. It's an interinstitutional coordination system led by our Secretariat of Justice and Environment and the regional presidential delegates, because they have a more direct relationship with the police officers, the police forces, the prosecutors, and that's why it was better to act this way, understanding that it was an insufficient document, and that's why we should move forward towards the protocol. But the process, the PPA, that is the Escazú participatory implementation process, PPA, is also underway. And we want to bring together the concerns on the basis of participation, the concerns of defenders, to be able to identify other mechanisms for the defense and the protection and other instruments that we can perhaps develop, and for them to be part of our institutions. So those are the three instruments that we are working on currently. But we understand that the participatory process is going to significantly contribute to this process. Okay, thank you for all the interventions. We don't have any more time for questions. We do have a very short break. It's 15 minutes only to have a cup of coffee. And Florence's proposal said, let's continue talking during the break. And I know there are more questions. Perhaps you can make questions directly to the heads of delegation. And we'll come back in 15 minutes because we have to continue with the agenda. And then we need to meet with the heads of delegations for the election of the committee. So let's come back in 15 minutes. Thank you.
Bueno, nos vamos acomodando, vamos entrando y
Okay, let's start. Let's see if we can start with the second part of the last session that we have scheduled for today. I'm going to call on the Secretariat so that the Secretary comes back. I hear the bell outside.
Muy bien.
Qué bueno. Se van acercando. Vamos a tener...
So we're going to have the presentations by the countries, and then we're going to have 4 international stakeholders that are very important for our agreement. Someone who works at the Secretariat. Okay. The doors are closed, so we're going to continue with the 3 countries that we have: Mexico, St. Lucia, and Uruguay. So if you agree, I would like to start with Mexico. Camila Cepeda, General Director for Global Issues of the Secretariat of Foreign Affairs. Camila, you have 8 minutes. Thank you. We already had a side event on Wednesday about everything we do. And I would like to take advantage of this opportunity to say what we don't do and to share with you the lessons learned and the challenges, the mistakes, and what can be improved. Because I think that we learn much more from our mistakes than from our best practices. So something to highlight is that it was important to define internal governance for the follow-up of this agreement. And one of the main challenges that we faced was to identify what government agency, was the one that had to follow up the implementation. So the natural thing that takes place in most of the countries is to go to the Ministry of the Environment. So we talked to the Secretariat of the Environment, and they told us what their concern was. And they said that the agreement went beyond the environment, because the Escazú agreement includes all development, all infrastructure projects that are implemented will have an environmental impact. So how can the Secretariat of the Environment tell their counterparts what to do? So they asked the Foreign Ministry or the Secretariat of Foreign Affairs to provide support with all the different branches of government. So we said, okay, but there was a small detail, and that is that the Foreign Minister doesn't have enforcement power. And so the next challenge was how to convince the counterparts to join, to be on board of this project, because they thought they had nothing to do because of the name environmental, right? And so we had to organize many seminars, many training seminars. And so the first lesson learned was it's not worthwhile to organize in-person webinars or in-person seminars, because the memory is lost when there are changes. We have 299 governmental entities. And if we think that the Escazú agreement had to go beyond the federal agreement, we can say that we have more than 2,000 municipalities. So it's impossible to train everybody, particularly because the authorities of these municipalities change every 3 years. And so after having organized 300 trainees, we said, okay, we're never going to finish. And the government changes, administration changes, and so the first lesson learned was it's better to have modules that are online that the officers can have access to, and also if you have mechanisms for ongoing training, when perhaps this could be a mandatory course and that can be left in a virtual repository. So we stopped doing in-person trainings, and we created these virtual or online mechanisms so that any official could have access to throughout time. So this is the first thing that we learned. And then regarding coordination, we have another challenge here, and that is that coordination is not just at the executive branch. Escazú has to be harmonized. I mean, the legislation has to be harmonized, and Mexico, the advantage for Mexico is that the agreement of Escazú is harmonized with many of our regulations, but we need to harmonize this throughout the country. We have 500 or more than 500 representatives, and we have senators. They change every 3 years, and so we have to create repository of information. And it would be like the CLAC, which has an observatory. And even worse is the judiciary. In Mexico, we have, of course, we have a division of powers that are autonomous. The branches of government are autonomous. And so the executive branch cannot tell the executive what to do, or the judiciary what to do. And so there had to be sort of a process of convincing, right? And we started communications with the Council of the Federal Judiciary and the Supreme Court, and they already see that they are receiving in their courts people advocating for Escazú, and they see that it would be better to all get on the same page. So we have to convince the federal agencies over which we do have jurisdiction as the foreign minister. The idea was for each one of them to lead one of these subgroups divided into the 3 rights of access. So we have regulations regarding access to information, but this is only for federal bodies. So only federal bodies are obliged to submitting information, and that is not the case for the private sector or the more than 2,000 municipalities. But we have the Secretariat of the government, which already has participatory consultation mechanisms. So in Mexico, it wasn't that there was a gap of provisions or mechanisms, but that the problem was that these mechanisms are not working that well. So we need a change in the vision and a significant improvement as to what we need to do. Regarding access to justice, we identified that we had a unit for the defense of human rights within the Secretariat for the government, and that there is a protection mechanism for journalists and human rights defenders. And here we've also identified that there are representatives that are defenders of the environment that are already included in this mechanism, but at the same time we don't have a specific protocol for Escazú. And so I'm talking as fast as I can because I only have 2 more minutes left. And so very quickly, challenges regarding access to information. We see that even though we have an online repository, in the field, in the territory, not all vulnerable communities have access to the internet, and therefore it's not useful to have a repository if we're not reaching those communities that are the most vulnerable and that perhaps their main language is not Spanish. So we need to translate. We have up to 68 indigenous languages. It's a challenge, of course, but it is important to do other kinds of strategies in addition to the repository. And regarding access to participation or engagement, how to go from an exercise as to what we want and to the reality, right? That is inclusive to it exists on paper, but in practice, it's not so much. So this is done before, and so here we have to work hard with all the agencies, with all the authorities, to insist that it has to be done before the projects are developed, not when you already have a project and when they want to meet the requirement in the aftermath, right, after they have the project. So this is one of the main challenges we have, how to ensure that there is representativeness of all the sectors before. We have to go to the territory, we have to go to the communities, but how do you get to very remote areas where we don't have perhaps influence there or jurisdiction even. In the south of the country, they have their own habits, and there's an additional challenge there regarding gender perspective, because there are communities that don't allow women to be in the decision-making process. And so we identified, and here I want to put this on the table so that later we can develop on this. We need to develop a gender action plan for Escazú, and so I'm proposing this to the parties, although this is, of course, not for this COP. Clark, please don't kill me. But moving forward, it would be a very good idea to make a decision regarding this topic. And regarding access to justice, and I know that I ran out of time, here we see many more challenges and many more obstacles, and that is because the courts are local. So justice is administered at the local level, and we need immense training, not only to raise awareness about the Escazú Agreement, but also about how we have to treat environmental defenders, and our mechanism of human rights defenders and journalists is focused on cities where we do have protection mechanisms, where we can implement vehicles, we can protect them. But if the person lives in the middle of the jungle or in the middle of the mountains, how can we protect that person? It's not so easy. Nobody has the magic wand or the solution. We're trying to think about how we can ensure conditions, and the ideal would be that we wouldn't have to defend them, or that we would just give them all the mechanisms beforehand so that we don't have to protect them afterwards. And then I wanted to mention some international cooperation projects that we are developing with the French Development Agency. We are implementing guidelines and protocols for access to justice and how the different bodies should respond to environmental defenders. With the German Cooperation Agency, we're developing a governance mechanism as well as that is similar to the Committee for Support and Implementation and Compliance, and we're doing this with the civil society, with academia, and we want to have an intercultural perspective, intergenerational perspective, and a gender perspective. And with Ecuador, we're developing a 3-point cooperation project, and with the Autonomous University of Mexico and the Human Rights Commissioner for Human Rights in Mexico, we're developing metrics, because we believe that this body should develop monitoring and assessment metrics or indicators to see how we're doing as a region. So I'm very sorry to be talking so fast. I apologize to the interpreters, but I wanted to say as much as possible in 8 minutes. Thank you.
Muchísimas gracias.
Thank you very much, Camila. And now it's the turn of St. Lucia. Kate Wilson.
Sustainable development, innovation, science and technology, and vocational training. Kate, you have the floor.
Thank you very much, Madam Chair. I want to bring you warm greetings from the government and people of St. Lucia, and to say how pleased we are to have been working with a consultant contracted by the Escazú ECLAC Secretariat to develop this implementation roadmap for St. Lucia. Our roadmap is aligned with the substantive articles of the Escazú Agreement, Articles 2 to 11, and we are, so far, we did a baseline assessment to ascertain what is it that we require for implementation, and we have noticed that St. Lucia does not have any constitutional or legislative guarantee for the rights to a healthy environment, so which is mandated by Article 4.1 of the Escazú Agreement. But we have in place our National Environmental Policy and National Environmental Management Strategy from 2004, which includes the principle that all citizens, including those of future generations, have the right to a clean and healthy, safe, and productive environment. We also have our Legal Aid Act, number 6 of 2008, at clause 4.2, which gives access rights to those who need legal aid. So what our roadmap has done, one of the main recommendations of our roadmap, is to amend the Constitution so that we have the right to a healthy environment. In terms of access to information, while, as I said, we have no specific law on access to information and no specified procedure on how that right to access to information should be exercised, as is required in Article 5, we have a number of recommendations from our roadmap, and that is to enact our Freedom of Information Bill. Our bill has been sitting there since 2009. We've done a lot of work on it, and we are ready to send it towards Parliament. A number of changes that we want to see happen first with that bill, and I'm not going to go through all of them, but one of the main things is to reduce the period for extending the time to respond to a request from 40 working days to 20 days, that information should be disclosed at no cost in as far as its production and delivery is done, that there should be a waiver when we are dealing with persons that are vulnerable and persons in special circumstances. And of course, the public authority should state its legal basis and its reasons justifying any refusal of a request for information. In terms of generation and dissemination of environmental information, St. Lucia already has in place a national environmental information system. We have placed the website here. You can look at it at your leisure. So we are in keeping with Article 6.3 of the Escazú Agreement. We have our open data portal and policy up and running. We have our early warning system in place since 2018, and we are going to improve on that. At the moment, we have no pollutant release and transfer register, which we are required to have under Article 6 of the Escazú Agreement, but we are going to amend our Waste Management Act to establish a pollutant release and transfer register covering air, water, soil, and other pollutants. And we have Ms. Yasmin Jude at the Department of Sustainable Development, who is working closely with the pollutants board, the pesticides board, sorry, to do just that. And of course, we have before the Attorney General's chambers our climate change bill, which has provisions for generation collection and public access to climate-related information. In terms of continuing on that vein, we have already produced our State of the Environment report since 2009 and 2015, as is required under articles of the Escazú Agreement. Our St. Lucia Bureau of Standards, in collaboration with our Department of Commerce, we are working to ensure that consumers and users have efficient, relevant, and clear information on environmental quality of goods, services, and the health effects to encourage sustainable production and consumption patterns, as is required under the Escazú Agreement, and also to disseminate information regarding concessions and agreements. One of the major gaps that we have, and we heard the recommendations from Jonas Ibbotson this morning when he spoke, and that is to encourage, we are in the process of doing that, encouraging sustainability reports from the public and private companies, as well as to develop an independent performance review of those. So that is in process. In terms of archiving and documentation, St. Lucia works very closely recently with the Mexican government. We had a course on the preservation, archiving, and documentation of cultural heritage, and particularly in the context of disaster risk reduction, and we did that for various stakeholders. So we want to continue along that vein. This is just a shot of one of our early warning systems here for flooding and tsunamis. Our other roadmap, very quickly, recommendations in terms of access to justice. We are amending our Physical Planning and Development Act to allow for a challenge to the decisions, acts, and omissions that would adversely affect the environment through the tribunal and courts. We are strengthening the Office of the Parliamentary Commissioner. So Mrs. Mathray should rest assured that we are coming. We are going to be giving her some sort of assistance. We are going to include the right to a healthy environment as a basic right in the Constitution of St. Lucia. And we are also in the process of developing a special policy in keeping with the provisions of Article 9 for protection for human rights defenders. In terms of public participation, again, we are going to amend our Physical Planning Act. In fact, it has started. Our Public Utilities and Renewable Energy Division under a project have begun to review it, and they are enacting environmental impact assessment regulations. And a number of things that they are going to do is to ensure public participation in decisions, including revisions, re-examinations, and activities and processes that may have a significant impact on the environment, including health. And of course, we are going to amend our section 47. You can have a look when this is placed on the Escazú website and read it at your leisure. And of course, as I said before, we are going to enact our climate change bill, which has many provisions in terms of public participation. In terms of our timeline, when we were working on the Escazú roadmap with our consultant, and this is our consultant is Danielle Andrade Goff, Mrs. Danielle Andrade Goff. She's no stranger to the Escazú process. She's a Jamaican lawyer and a former elected representative of the public. So we're working with somebody who knows what she's doing. In February, we did the first one, which was the baseline assessment. And in March, we had the step 2, which is our stakeholder mapping. We needed to know who we were going to deal with, who is going to help us, move that process along. This month, we have step 3 and 4. We've already developed an institutional coordination and governance system, and that is already, we are going to be deciding on that very soon. Step 5 is our information and participation strategy, and step 6 is our regional cooperation. So we have to decide here as to, in terms of our governance system, whether we are going to have a national coordinating committee with cabinet approval by a cabinet decision, or whether we are going to have a multi-stakeholder forum, or the two of them. And as I said, we are going to be formalizing our participation strategy. So here I want to thank, first and foremost, the consultant, Danielle Andrade, for assisting us in that process and marvelous work that she's done. I want to thank the Escazú Secretariat that continues to give us sterling guidance and support. Mr. Carlos de Miguel, David Barrio, Gabriela Bedelis, Andrea Sanhuza, Maria Andreza, who worked with us very closely with that roadmap. I hope I'm not missing anybody else for ensuring that our participation here in Argentina was seamless. I want to thank the government and people of Argentina for this warm welcome. Last night I was so, taken by all your music, your country that is full of culture, full of circumstance, full of history. I want to thank you for that. And I want to thank, my inner tribe that always gives me support when I need it. Ruth Spencer of Antigua and Barbuda, Ms. Yaya Marine Coleman of Belize, Mr. Joseph Antoine of Grenada, and all my colleagues, the working groups that we've worked together. And of course, I do not want to forget my team at the Department of Sustainable Development. Without you, I could do absolutely nothing. So once again, Madam Chairman, I want to thank you so much. We will continue to work along those lines to ensure that the implementation process is effective and that we have a roadmap that is reflective of the needs and aspirations of the people of St. Lucia. So thank you very much.
Thank you very much, Kate. And I'm glad you like the music, because in general you expect tango. So we are not only tango in Argentina, so I'm very glad you like the music. Y ahora a continuación vamos a...
Now we shall have Uruguay, Florencia de Castro, Director of the Division for Legal Counseling and Regulatory Counsel under the Ministry for the Environment. Good afternoon. Thank you very much for that. In the first place, we wanted to greet all the delegations and representatives of the public, and we wanted to thank ECLEC and most particularly the Argentine Republic for this organization and the warm welcome. Today, we are here to talk to you about the process that we are walking along in Uruguay to put together a roadmap and have a national action plan regarding the effectiveness of the rights of access. According to the laws and best practices in Uruguay and the caveats of the agreement. We have a schedule with a term, which began this year, in spite of the fact that in January in Uruguay, January is summer. And in general, everything is quite cross-cut by holidays and annual leaves of officials. But all the same, we started to work at the roadmap, committing to complete it by June, that is to say halfway through the year. So the term is a 6-month term for execution. Coordination is carried out by the Ministry for Environment in Uruguay, the legal department, with Marcelo Cusillos as the national focal point, and we thanked for the cooperation we got from ECLEC, and 2 lawyers in particular who are consultants. They gave counseling in this respect, surveyed the assistance and all the materials we need to put together the roadmap. As I was saying, the launching took place in January this year. Though there were preliminary activities in November and December, we understood the launching took place after a meeting with benchmark groups, counterparts, where different officials from different institutions might become pertinent stakeholders and might put together very important inputs all along the process. We called upon them at different institutions, and with this January meeting, we consider that is the kickoff of this first stage, which was certainly fruitful. The second stage meant drafting a map of actors and stakeholders, who are the individuals, who are the persons that we believe can be very instrumental to this activity, for this work. We consulted with them, we interviewed them several times, had dialogues and consultation processes with them personally, so as to survey the inputs and all their background that they could contribute to this activity. In the third place, we put together what we call a basic regulatory line and the best practices that are carried out in our country. We identified different standards, whether national or at a department level, in order to be able to trace this regulatory framework that was a starting point and that we needed to adapt to each situation. And then we've also anticipated other 4 stages that will take place as from next month. As I say, this is halfway through the year, the different presentation and validation, the proposal for validation we have institutionally, the strategy for participation and information, and the identification of possibilities for regional cooperation, which we had already mentioned. So as you see, we're upon closing the regulatory baseline, and we're walking along the 4th stage, which we anticipate for the coming month of May. I seem to have skipped an overhead. We managed to identify we've been identifying the state of the state quo of the background data regarding what we expect to do in our country as to rights of access, to survey the situation, where we're standing and where we're heading to. Regarding access to environmental information, We believe that is our stronger pillar. Of the three rights, we believe this is what is more adapted in line with the agreement. We have a law for access to public information, which is not specifically environmental, but we have it since 2008. And actually, it works very well in our country. It provides for access to public information with considerable terms. The term to supply the information is 20 days, quite higher the expectations than what the agreement sets forth. And we also have a general law for the protection of the environment, year 2000, embracing the right to environmental information as an environmental policy in Section 6 of this law. There also is an observatory, a national environmental observatory created by law in 2013. And besides all these specific rules as the assessment of environmental impact or territorial management, the access to public information is also very important. As to the participation in environmental matters, there's also permanent environments created in different standards, like COTAMA, which is an agency to provide consultancy regarding the environment, and others which are not permanent, which prevail for specific areas like, for instance, department surveys or things to do with land management or human rights. Finally, as to the state of affairs regarding access to justice at home in Uruguay, we believe this is the pillar where we're not doing that well, or which needs more effort, so we believe there's a bigger opportunity for improvement. The laws date back to the 80s, that talks about diffuse interests and also constitutional proceedings or proceedings brought to protect constitutional rights, which we call amparo in Spanish. And as to the areas for improvement, we believe that legislative design of collective processes is one of the issues that we're really interested in putting into practice. Hand in hand with what our colleague from Mexico said, we also see eye to eye with judicial operators. This is a need for us in all aspects, and this is how strengthening that pillar, I believe, would be significant. As to the participation in environmental matters, we also believe that we do have opportunities for improvement, and to this effect, the Ministry for Environment has created a task force in order to analyze in-house which are the practices that are being carried out, because though the regulatory framework provided for exists, we believe there is room for improvement and that there are a lot of practices that need going over. So this task force is working with the objective of, in the short term, putting together and forwarding certain recommendations pursuant to improving this pillar. And finally, as to environmental information, we are really committed to the provisions of Section 6, Item 4, when we consider that the design of a register of emissions, of contaminants emissions, we think that this right would be much better off if we tackled this in this respect. I hope I haven't taken up too much time. Thank you so much. And please feel free to get in touch with me, and this is my email in case you need it. Thank you very much.
Bueno, muchísimas gracias a
Thank you, Uruguay. We're going to leave the observers and the public interventions for the end so that we can move forward with this luxury panel, as I have here. It's going to be fast. We gave each one of them 3 minutes. Let's see. Remember that we have translators, sign language translators, and English, Spanish translators as well. So this is like a competition to see who speaks the fastest. So I'm going to introduce them so that they can take the floor. Juan Bello, he's a regional representative for the United Nations Environmental Program. He is a cooperator with us. Thank you, Chair, Madam Chair, for the United Nations Program for the Environment, or the Environmental Program. It's an honor to take the floor in this meeting. It's the second meeting of the Conference of the Parties of the Escazú Agreement. UNEP continues committed with the full implementation of the agreement and thanks you for the opportunity to work together with you for that. We don't underestimate our ambition or task. Escazú is our most powerful tool to build the rule of law in environmental matters and in the materialization in Latin America and the Caribbean of the human right to a clean, healthy, and sustainable environment. The Escazú Agreement went into force 5 years ago, and a lot of work has been done since the COP1, and the organization of this extraordinary COP in Buenos Aires expresses your intention to accelerate the implementation for the agreement to reach its ultimate objectives. Congratulations, Argentina, for hosting this event. Congratulations, Uruguay, for your excellent leadership in the work that has been done since COP1. All the member states, particularly Grenada, Belize, and Chile, for their recent incorporation. And I would like to thank the public as well for their exemplary participation. After the historic resolution adopted in the Human Rights Council in 2021, on July 28, 2022, the General Assembly of the United Nations recognized for the first time that a clean, healthy, and sustainable environment is a universal human right. The resolution of the General Assembly affirms the importance of a healthy environment for the enjoyment of all human rights and urges the states, international organizations, businesses, and other stakeholders to intensify their efforts to ensure such universal right. The promotion, protection, and respect of the human right to a healthy environment, including procedural rights that are part or that are the pillars of this agreement, such as access to justice, environmental participation and justice in environmental matters, has to be strengthened at all levels to ensure that people can have adequate mechanisms for protection and to ensure that laws are complied with. However, we need to assume that environmental rights are not fully realized or materialized by the owners of those rights, and are not fully promoted by promoted or enforced by those who have the duty.
Work for the people they have been designed to protect. The Escazú Agreement has been designed to protect the rights of all Latin American and Caribbean peoples and to protect the diverse environment of our region. In this way, it contributes to attend the triple planetary crisis of biodiversity loss, climate change, and pollution. As the environmental voice of the United Nations, UNEP would like to express a great recognition to the Latin American and Caribbean region for this journey, which started in 2012 and continued in Costa Rica in March 2018 with the adoption of the Escazú Agreement. UNEP congratulates all the people and institutions who have been part of this great endeavor. Your work during the last years not only helps guarantee more access rights for the people of our region, but it also addresses the current threats to environmental human rights defenders, a tragedy of our times, and one that is at the heart of our work in UNEP. As the time for implementation has come, we shall renovate our commitment and reinvigorate our actions. Promoting pending ratifications continue to be an urgent and major assignment. We have been advocating towards this purpose in all the opportunities we have had, for instance, talking with ministers and political leaders of the countries of Latin America and the Caribbean. Our executive director, Inger Andersen, has encouraged leaders to join as soon as possible. We do hope and trust that the agreement will have all the Latin American and Caribbean countries as parties to this agreement. The Forum of Ministers of Environment of Latin America and the Caribbean will have its next meeting in October. This regional political gathering is a platform to advocate loudly and to encourage others to join and to be part of Escazú. I also want to mention that there is a working group of this Forum of Ministers of Environment on Gender and Environment. Is currently chaired by Chile, and that, I'm sure, will be a very good platform to support the development of the action plan on gender, as mentioned by the Mexican delegate a few moments ago. So let us work. Let us also work towards the full achievement of the ultimate objectives of the Escazú Agreement. UNEP will stand by to continue our cooperation with the Economic Commission and all relevant partners to work with countries in Latin America and the Caribbean to assist in the implementation of the agreement. Furthermore, count on the region's cooperation in supporting similar activities in other regions and subregions of the world. Your experience and lessons learned throughout the process are of great value to them. Para terminar,
to wrap up, I'd like to reflect about the importance of integrating youth and diminishing the intergenerational inequality gap in all jobs connected with the implementation of the agreement. Under the leadership of the UNDP and together with UNICEF, we had the opportunity to talk to youth in preparation of this COP to ensure effective participation of the youth in the implementation of the Escazú Agreement. Yesterday, we also talked about the voices of the civil society, such as Fridays for Future, LATAM, as defenders of this planet, and a group of other youth environmental networks. These groups emphasized very clearly that the transformation stems from increasing ambition, providing safe environments to listen to vulnerable communities, recognize the experiences that are already in the territories. There is a journey ahead regarding access and participation of the youth in decision-making spaces and the need of an intercultural approach that is representative to give sustainability to public policy. UNEP is committed to work in that. Thank you.
Thank you very much, Juan Bishop. It's impossible to do it in 3 minutes. Perhaps in French? Okay. I'll leave you to it. So another great partner, UNDP, that's been working with us throughout the region, not just at Escazú, but also climate change, and so many activities carried out at the Secretariat. And this is why I would like to introduce Claudio Tomassi, Res Rep of the UNDP in Argentina. Good morning, or rather good afternoon, everybody. In the first place, congratulations to the chair and the Argentine authorities for the wonderful organization of this COP2, and to the Secretariat for having opened up this space for dialogue here. Clearly, the Escazú Agreement is key for the region when it comes to access to information, citizen involvement, and access to justice in environmental matters. Today, we celebrate this extraordinary COP, and we want to make use of it to highlight both the commitment of the UNDP regionally, as well as the job that we've been carrying out, considering this historical assessment of Principle 10 in Rio 1992 and the international treaties on the environment, in line with a technical note that we've put forward this morning, which is the right to a healthy environment that we've put together precisely with the UNDP and ACNUR friends. So this is the base and the spirit of our strategic strategic documents, as well as the efforts to carry out this project in the territory, as well as the social safeguards by accessing the 3 accesses and working with communities that are in a vulnerable position. In turn, Latin America and Caribbean lead biodiversity and lead loss of biodiversity, because there is a limited capability for political and financial solutions that help address the triple crisis. The countries are highly dependent on fuel for the agricultural sector. At the same time, the region has high potential for positive impact for the preservation and sustainable use of biodiversity. 5 of the 7 most diverse countries worldwide are in Latin America and the Caribbean: Colombia, Ecuador, Mexico, Brazil, as well as others such as Chile, Argentina, Peru, and Bolivia. And all this may have a positive impact as a policy for preservation. It's a region that provides great possibilities for partnerships to address this crisis. The civil society is strong, the academia is robust, and there is a growing interest of financial institutions and the private sector to work at the transformation of finance, and economy provides for social inclusion. Of course, the idea is to have effective human rights and the 2030 agenda, where the sovereign debt is growing in many countries, and the rush that we're going through financial issues to be able to meet SDGs. Every day, responding to the crisis, we supply help in the vertical funds, the Green Fund, the GEF Fund, to be able to implement the international commitments that were undertaken. These are significant vehicles, and right now we have a portfolio encompassing more than 100 projects for a value of more than $10 billion. Specifically through climate change, the offer to strengthen the countries is the strengthening of national contributions, and that will be 28 of the 33 countries in the region, supporting it regarding climate, funding nature, citizen involvement, and all of this in an integrated view of development, participation of youth, and fair inputs. We are working on follow-up after the 2020 pandemic, and we've started a new line of innovation on climate change, peace, and security in Latin America, which expects to establish a link between climatic action and solving the crisis. Escazú provides a framework to carry out this multidimensional work. We also want to express our commitment with the governments, with the civil society, agencies, technical secretariat, and implementation of the Escazú Agreement regionally, not just within the framework of UNDP, but also considering the stock of current projects, the biodiversity, climate action, sustainable consumption, strengthening governance. It all helps for sustainable development. The context of this is the governance crisis that we see in all the world. We need to redefine social agreements to guarantee truly inclusive justice focused on the people. This demands a quick and innovative response, and to address environmental injustice, thus recognizing and tackling social and economic differences brought on by the climate change. Though global, the response capability and the tools to face it are not the same everywhere. The population that are in vulnerable positions end up by suffering more, and this is where we need to pay more attention so that the land doesn't lose its proper level. So it is fundamental to generate the right conditions for governance in an effective way, and thus maintain the cohesion of the social fabric in times such as this. Finally, we can't but mention that together with the the climate crisis and the reality prevailing shows that COVID-19 has put in value the need to take regional consistent action. And Escazú is a key tool for inclusive pluralism without leaving anybody behind.
Muchísimas gracias, Claudio.
Thank you, Claudio. Tomorrow we're going to be discussing an important topic, which is the Voluntary Contribution Fund. So I have to take advantage of telling you that a GEF fund for the implementation of Escazú would be very in order, let's say. So the proposal is on the table. Thank you. And now we're going to continue with Beatriz Anchorena, the head of the Network for Transparency and Access to Information of Argentina. Welcome, Beatriz. Hello, everyone. Thank you, Cecilia, for the invitation. I would like to thank ECLAC as well. I am the director of the Agency for Access to Public Information, which is an enforcement agency regarding transparency, protection of personal data, and access to information in Argentina. But I'm sitting here today to represent RTA, the Network of Transparency and Access to Information. It's an Ibero-American network that brings together more than 18 countries and more than 40 institutions from those countries, and most of the protection agencies or the agencies that ensure access to information. So in this joint work that we want to conduct, that we need to conduct, particularly for environmental policies, we think that transparency is a substantive dimension of the entire public policy cycle and all the fields also of public policy. In this case, we're talking about environmental policy, and the network in each country can support, and we can work together in these different topics, which have to do with the access to information processes, the procedures, and the claims, that is to say, how to ensure information to all citizens, and also in the chapter of active transparency. We are convinced that it's necessary to take a quality leap in active transparency. Active transparency is not to make the resource administration, resources, payroll, and procurement more transparent. We need to make more transparent public policies, decision-making processes, public problems that are prioritized, and the solution to which are the strategic policies of a government. So all this knowledge that can be contributed by the network of transparency and access to information can be useful for the implementation of the Escazú Agreement, mainly in connection with the agencies that ensure access and all the work which is organized differently in each country and is heterogeneous. But as a network, we have a very broad field of expertise, and we can be a specific bridge for the implementation of the agreement. For this, we need to work in building state capacities of coordination among different agencies and public institutions, because many times the effectiveness of our results have to do with the capacity of coordination to have effective public policies. And in this regard, we are available to train, to organize seminars, and something that is essential that I heard here today is citizen engagement or participation, which is also always on the agenda of the governance and the meetings of the Network of Transparency and Access to Information. And let me tell you that next Monday and Tuesday, the network is going to meet here in Argentina. We have a closed meeting, and then on Wednesday, we have an open international seminar where Cecilia is going to participate in the panel regarding the Escazú Agreement. But we're estimating that Monday and Tuesday, when we define our annual work agenda, we will be opening another work group in the network that has to do with access to environmental information and the implementation of the Escazú Agreement. So, from that focal point, I think we will be able to have effective coordination to push for this very important work that you are doing in the COP. And to wrap up, I would like to tell you that ensuring access to information is ensuring access to rights. This is essential for us. Ensuring access to rights requires state capacities, requires a government that is close to the people, and I believe that it requires an environmental social contract, and that's what we're here for today. So you have the network available, you have the Agency of Argentina, of course, and we are available for whatever you might need. Thank you.
Thank you very much, Beatriz. This will be next week then. And I remember that a week ago there was a significant meeting for Argentina, which was the Worldwide Forum of Human Rights, and we had the pleasure of having organized it, and it was Fernanda Gil Lozana, the director of the International Center to Promote Human Rights under UNESCO, and we're going to ask her to take the floor now. Welcome. Thank you very much. I want to thank all your patience all this time. I know it's been an intense day, so I'm going to try to be as brief as possible. And Cecilia in particular, I want to thank you for the invitation. It's an honor to be participating in COP2, the Escazú Agreement, representing the International Center for the Promotion of Human Rights, sharing this room for this international dialogue. CIPDH is an agency that resulted from an agreement between the Argentine state and UNESCO to contribute for the protection and defense of human rights worldwide. This happened in 2009, and it was a big gesture of the UN considering the public policies in Argentina regarding human rights, remedies offered to victims, among other things. This center works under the human rights environment and is sponsored by UNESCO. It's a Type 2 program, and we value the fundamental contribution that Escazú Agreement provides when it comes to protecting the environment and human rights, particularly in the region, but also as a reference in connection to the rest of the world. And thus, since last year, we've fostered a series of trainings aimed at, in particular, local governments with the purpose of disclosing their principles and lending a hand at striking partnerships and cooperation networks to consolidate environmental democracy. We are aware of the delicate situation that people defending the environment and Mother Earth have to go by in our region. They fight to take care and care for our wetlands, native forests, our flora and fauna, hydric resources, water resources, and so many other common goods, and how they are heard and have a voice against the climate change that is prevailing. We know we inhabit the more dangerous region because of the attacks, hunt-downs, and deaths that they have to endure because of the state actions and corporations. Taking into consideration the serious situation and based on reflections and lessons learned, we shared in the Third Worldwide Forum of Human Rights, which was held here in March in Argentina, we've designed at this center a tool that we expect will contribute and help its protection. I'm happy to say that last year I signed a resolution for the creation of an observatory regarding people defending human rights and environmental matters in Latin America and the Caribbean in the framework of this center. We seek the observatory to become a space for ordering, systematization, and analysis of situations and how this affects the people defending human rights and environmental matters, and to contribute to strike public policies that will guarantee a safe and fit environment, generating protection measures, access to justice, and providing answers. The objective is to be able to systematize all that information in an interactive map that will be a good way to make a consultation and make visible the situation of the defenders of the environment in our region. We will also foster education programs and trainings and programs to raise awareness based on the conclusions and findings we arrive at. We have experience with these tools because we already have a program that works on memories in the world, and a lot of people consulting, a lot of people, a lot of countries, and especially Argentina for high school and university teachings. We know it is not the solution to the problem, but we believe that it may contribute to make visible and raise awareness about the rights of the people who are the defenders of human rights and environmental matters. This observatory would have the support of universities, labs, indigenous people, human rights agencies, and civil society organizations, among other strategic partners, for which we shall enter into different cooperation agreements. And we hope we can articulate our work with other government initiatives and initiatives of the civil society in this regard. And we expect to cooperate with the bodies of the Conference of the Parties of the Escazú Agreement. Not much to say. We will disclose more details soon, but I wanted to take advantage of this opportunity to communicate this contribution of the International Center for Human Rights that strengthens the capabilities of the states upon the survey and analysis of how rights are affected, and these are the rights of the environmental defenders, and thus the possibility of thinking on better public policies for their protection. Thank you very much.
Thank you, Fernanda. And we would like to thank you and applaud you for the creation of that observatory, which I think is going to be a fundamental tool for the implementation of our agreement. It's one of the most urgent topics in the region, which is to work in the protection of our environmental defenders. So this is very welcome. Your announcement is very welcome. Before opening up the space for conversation, the observers and the state parties, I would like to remind you of the fact that after this meeting, the heads of delegation of the states parties and signatory countries have to stay because we're going to deliberate regarding the candidates to the committee. We're going to do that in this meeting, so please don't leave, so that we can do it in this room to be able to use the interpretation service. Okay, so we're going to open up the floor for questions, and before we started with the public, but now we're going to start with observers or states parties. We have Colombia first, and if there are no other countries, then we'll go to the public. Okay, so Colombia, you have the floor. Good afternoon. Of course, I'd like to thank the government of Argentina for hosting this very important COP. The presiding officers, I'd like to thank the presiding officers and the authorities of the governments of the countries, the UNEP, UNDP, civil society organizations, and the communities that are present here. On behalf of President Gustavo Petro, who is also an activist, and our Vice President, Francia Marquez, who's not only an activist and a social leader, but also she is a person that has been threatened and has been the victim of some attacks. Susana Mohammad is also a very recognized activist, but odd enough, many of those in the government were activists for many years. The president of the mining directorate has also been an activist for many years, and we never thought we would be part of the government and that we would be able to make transformations from within. We always tried to do it from outside, and it was a very complicated fight. But we're moving forward, and these are transformations that are not easy. And of course, you know that in Colombia, the three rights, the essential rights of the Escazú Agreement, and of course the right to life, the protection of the right to life, are part of our legal framework. But Escazú is here to strengthen us, to cooperate, to help us move forward in this fight, which is a joint fight and a struggle in Latin America and the Caribbean. The government of President Santos sent a bill. Excuse me, I meant to say President Petro. I'm sorry, that was very bad of me. So President Petro in February last year, sent a bill, and in November, the Congress approved the Escazú Agreement. The president enacted it as law in November, and then there was a constitutional review that was sent, a request that was sent to the Constitutional Court of Colombia. This is going to take up to 1 month, but we hope that we will be part of the Escazú Agreement by the end of the year. So this motivates us to continue working and fighting, because we believe that. No, actually, we don't believe. We are implementing the Escazú Agreement. We're removing all the barriers that limit the access to information, limit participation, limit access to environmental justice, and we're trying to create the proper environments to protect the life of the environmental leaders, which in Colombia, the life of the people who defend the environment is very vulnerable. They're very much exposed. This year, we have had 57 people who have been killed when they were defending life and defending the environment. And it cannot be the case that by defending life or defend life, defending life costs their lives. And so I'm the director of the National Authority of Environmental Licenses, which is an entity that was created 11 years ago. And these processes, of course, have development projects. And here we have many challenges and part of the transformations that were created in the country, because, of course, what we identified is that development of these projects creates conflict in the territory. The idea is how to take advantage of the Escazú Agreement to have participation that is active, participation of the communities that are affected by the development of this project. In our authority, we're including enlarged participation spaces, which is not provided for in any provision, but we are calling on the communities to listen to them. When we go to make an assessment visit, we call on them and we listen to them. There is a wide legal framework regarding public hearings and citizen participation. Anybody can be part of a ministerial process or licensing process, but we expanded that. The law establishes 3 procedural points to be part of the process. If we're talking about collective rights, expansive rights, fundamental rights, because we need to materialize them at all times. Why only in 3 procedural steps? And so today, we ensure that any Colombian citizen can be part of an administrative environmental process. We recognize that through an administrative action, and we're moving forward in that direction. People are intervening in public hearings, environmental public hearings. So we convene public hearings to listen to communities, and sometimes they take 5 to 3 years, and we only leave 3 minutes for the communities, 5 hours for the authorities and 3 minutes for the communities, right? So if it's only 3 minutes, it's only 3 minutes for everybody, not just for the communities. We're going to put 5 women from the beginning. We're going to find a way for those mothers to be able to have babysitting services so that they can go and participate, because they are defenders too. So those are small changes that we're making, but they have a direct influence in the advocacy work. And this is part of what we have included in the Escazú Agreement. In Colombia, we have recognized farmers as the owners of rights. Farmers are very vulnerable. In the National Development Plan, which is the government plan, Mr. Preto, the president, created an institutional commission that would allow us to move forward in the implementation of the agreement. We have an agreement regarding water, and we also have institutional arrangements for the changes that have to be made in each institution. The environmental system in Colombia is very complex. There are authorities that are the different degrees of autonomies, and this is difficult. We also have people's consultations. Before, there used to be direct voting. Unfortunately, the government before did not support this project, and the Constitutional Court removed this possibility. We, for example, saw the Ecuadorian process that has these public consultation processes, and we're supporting these processes in Latin America. We want to reform the law on the environment. The environmental impact assessments demand focus on gender, a focus on human rights in environmental assessment studies. We're working in the change of the methodologies to conduct these assessment studies. We have terms of reference to include a human rights approach according to Escazú. We're working in our authority because we've had more than 500 appointments to request meetings, and we've had more than 500 meetings with the communities. There are 44 environmental inspectors. We have a national authority, but we are always present in the authority. Those inspectors talk to the communities, they analyze their activities, and they go to the central level. We're working also on a reform of the mining code, and here is a substantial issue, which is a Latin American issue, the public utility of these activities that sometimes lead to the displacement of communities. We need to create, of course, we cannot prohibit activities, but we have to find a point of balance. There are many displacement processes related to oil and mining activities because the communities have to leave the territory for a project to be implemented. What's the point of equilibrium so that human rights are protected and ensured and guaranteed? We're working on a law on environmental liabilities, and we are working a set of regulations and sanctions for the environmental issues. So the idea is to cooperate, and it's very important to have Latin American and Caribbean spaces because we have a very significant potential. As President Petro said, Colombia is a world power, and this is a challenge because the threat that we have in our country regarding our local communities that have many difficulties and are very vulnerable. And no doubt we are undergoing a civilization crisis, a social, environmental, and economic crisis. I want to wrap up with this. And Chair, please, I would like to go on to, excuse me, I want to say something that is very respectful. And that is in the election that we're going to have for the support committee, I would like to think about the representatives that are not parties still. And so when we enlarge the democratic principle, I think we need to include the possible candidates, and this would help us to move and to have a better understanding. And no doubt, I would like to thank the presiding officers for their commitment, their support in the implementation of the Escazú Agreement, ensuring the democratic processes. I think that is very important, and so thank you very much.
Buenas tardes. Good afternoon. I'm Valentina Camas Montealegre, and I'm the Assistant Director for Participation in the Ministry for Environment in Colombia. And I want to supplement Rodrigo's intervention by telling you that in the Ministry for the Environment, we've been working at consolidating the national dialogue system to settle social environmental conflicts. What we aim at is to arrive at territories, get to know the causes for social and environmental conflicts, and transform them positively by building upon governance, social agreements, which will allow us precisely to balance the field and involve communities, because it is they that know their land and their territories, and it was they who very often have to put up with the impact of those projects because they advance in those territories. We're also proposing oversight and environmental control programs. It's very important to install capacities in the communities, and for the communities to be the ones that control society and hand social controls to coexist with the system. And among other things, not to take up too much time, we wanted to tell you we are moving on in a strategy to recognize and protect the rights of the defenders of environmental human rights. And we believe the first step is to recognize the voice of defenders, considering that part of the violence that falls on defenders refers to stigmatization when they are identified as opposers to development, and we want to recognize them as the forefront fighting against climate change and defending the most important ecosystems in the country. And in this sense, we are also making institutional arrangements so that this assessment of non-risk demands collaboration, cooperation, and thus the defenders are at risk. I would like to close this, and I thank you very much for this short space award. Thank you very much, Colombia, and thank you for all you're doing. And we also hope for you to join. I think there's three of them, the three people. Tomorrow we'll have more time. I can only accept 1 minute each, 3 questions in all, because we have to stay here to reach on consensus. So if the team gives me a hand, 2 at the left, 1 at the right, they put up their hands, and that would be it. Let them have their mic. Please be brief so we can entertain more questions, and tomorrow there will be more time. Thank you. Good afternoon. I'm Maida Lopez Pileri, Mexico and Central America, forming part of the group of organizations which is following up and fostering the Escazú Agreement in Mexico. We coincide with the Mexican administration in the sense that there are more things to make progress than actions started. But we would like to tell you that the context in Mexico is even worse than what we heard of here. For instance, by listening to the representative of RTA, we wanted to comment on what is happening right now in these days against the National Institute for Transparency and Access to Information. On April 1st this year, the INAI plenary session was prevented from being convened as they didn't have quorum, given the unjustified omission of the Senate of not appointing 3 of its members. The fact that the plenary session of this body guaranteeing access to information is not complete is very, very serious, because in all, citizens are totally defenseless, and the right to access to information collapses as a nodal point of Escazú. Today, precisely, the Office of the High Commissioner of the UN for Human Rights in Mexico sent a letter to the Senate in Mexico so that the 3 INAI commissioners are appointed before the ordinary term is over. Very briefly, to comment other actions taken to obstacle the right to information. In November 2021, the President's office in the country issued a decree classifying information of pre-Machas and the Transseismic projects as something involving national security, which means that any application regarding these 2 mega projects could not be disclosed. The battle was fought at the Supreme Court of Justice of the nation, which in the end arrived at the conclusion stating that such measure was illegal, and besides that there was no proof of damage in the case that we need to disclose the situation. Additionally, we also want to tell you about the so-called Tren Maya train, an emblematic project of this Mexican administration, infringes a lot of the rights of the indigenous people and has been questioned by international agencies, infringing the right to access to information and participation. Likewise, the National Institute for Indigenous People has held consultations that there are no real consultations. The only thing is that they put in their forums, they take to the forums the workers and relatives of the local municipalities. And finally, as a defender of the territory, I'm Eugenia Pastrana, and we demand the Ricardo Lagunes, Ricardo Castillo, and Irma Galindo to appear with life, and Hermenia Hernandez to be released immediately. Thank you very much. Over there, could we have the mic over there, please?
I'd like to take the floor. Thank you, Carmen. Good afternoon, everyone. I'm Maria Selva Ortiz. from Uruguay, from Friends of the Earth. That's a network. This morning, we delivered to the Uruguayan delegation a letter systematizing a series of cases that we consider that last year the Uruguayan state infringed on these principles that we have and that were ratified in 2019 in the Escazú agreement. That letter was written yesterday by us after 5 o'clock. We distributed through different Uruguayan organizations, and 27 organizations signed it up to 8 a.m. this morning. And then we want to request that those organizations be part of this map that was made in March, because these organizations are not included. And we understand that there is a violation of an international treaty on human rights, but on the part of the Uruguayan state regarding access to justice, participation, and human rights. And these organizations are committed, and we thank them. We thank all the stakeholders that have worked so that we can be here today, so that we can have this very valuable tool. The organizations are committed to working for the implementation and cooperating in the implementation, because we understand that many things have been worked on from Rio 92. So for us, this is a big achievement that we can defend after all these years. And so we request the Uruguayan state to respect all those principles, and we will work with the state to implement this and to respect those principles. Thank you. Tomorrow we're going to continue with the interventions. I apologize now. We have the obligation to conclude this session for this first day of the Conference of the Parties. This is an extraordinary meeting, and as I said before, the heads of the delegation of the states parties have to remain here in this venue. I would like to invite the rest to leave the room so that we can continue with the deliberations in connection with the candidates for the Committee to Support Implementation and Compliance. And tomorrow at 9 a.m. we will continue with this conference, and we will hopefully have more time to continue having your remarks and opinions. Thank you.